हाँ, 2019 matter, IF for bail.
2019 regularization matter, affirmative matter. I've given several memos.
That is not taking option. I did not. I'm pass the order to post it to case to right in and message not cop. Who gesture my lord? They're not yet admitted, my place admission. Acted to me to listen the individual content matters in single court cases are disposed of only one judgment. My lord directed separate memo in contribution 5. I lost direction and filing the matter is 53.3. All the matter would come in CRLA, posted more than 11 years. Yes.
Pardon to means, my lord. I mean, DC, my lord.
Therefore, the senior advocate take care of. So, a completion is filed by the Union of India. I filed objection. Only 15 days last. I don't put it. Only 15 days to file objection to the statement filed by the Union. What statement? Counter affidavit has been claim statement. Union has filed, and similarly, applicant has respondent or employee also filed. Now, as the respondent employee, respondent employee. Let us wait. We are not taking up. Yes, Mr. Counsel.
Pardon to mention, my lord. I mean, DC, my lord. Item number 3, 4, and 5. Behalf of Mr. Bhavan Shankar Mishra. My lord, kindly taken up next week.
Matter request, please make a mention. Yes.
Supplementary list. Item number 1.
May I please alert? Already here, petitioner approached this honorable court by answer to WPC 3484 of 2024. My lord, my honorable court has directed to file specified from as per OGLS. My OGLS application is not considered by the government Tahsildar. I have preferred appeal, my lord, OGLS appeal. In meantime, civil suit is also pending on the scheduled land. My IA application dismissed. I have filed an FAO. But all are pending, but opposite party number 4 and 5 without considering itself trying to construct a wall in the scheduled land.
If the civil suit is pending, file appropriate application. Prayer at page 10 make a little class. Relegate the litigation before the civil court under 39 rule 1-2 as dismissed. Again now
also pending, my lord. FAO is also pending.
To file appropriate application, why have you come in the writ petition? If you have already taken recourse to the alternative remedy and the matter is sub judice in FAO, why have you filed?
All are pending without considering state is.
Mr. Counsel, you are to move an application seeking for interim relief in the pending cases. This writ petition is not maintainable. That is exactly what we want to say. Next step 3, disposed by Tahsildar in terms of the order of this honorable. This same is not a general challenge. There is a descriptive order
challenge, my lord, by OGLS appeal.
The OGLS appeal. Once they have relegated the boundary wall cannot be constructed by way of order of this only innocuous prayer there. Order 39 wall also rejected. Page 10. Not constructing illegal boundary wall. That injunction was moved before the honorable civil judge. Civil judge rejected. FAO pending. FAO pending.
Because according to him, that's pending.
The writ petition by the petitioner Ratho Pradhan. The direction to the opposite parties number 4 and 5, that is Tahsildar Daringibadi and Block Development Officer Daringibadi, for not constructing illegal boundary or wall over the scheduled land. From the averments taken in the writ petition, it appears
that the petitioner filed a civil suit bearing CS number 13 of 2024 against opposite parties number 1, 2, and 4 with a prayer to declare the petitioner has acquired the title by way of adverse possession and perpetual injunction against the opposite party in the court of Land and Civil Judge Senior Division, Paliguda, which the aforesaid opposite parties have already entered appearance, and written statement has also been filed. When the opposite party number 4 allegedly threatened the petitioner to evict him from the land, the petitioner filed IN number 3 of 2024 under Order 39, 1 and 2 of PC in the said civil suit. And had order dated IA Takeba dismissal by dated 1/8/2024. The IA was dismissed on contest. It further appears from the averments taken in the writ petition that the petitioner, being aggrieved by the order passed by the Land and Civil Judge Senior Division, preferred appeal before the National Session Judge, District Judge, Baliguda, by FAO number 8 of
9 of 2000.
8 election,
Sorry, ma'am.
Oh, God.
FAO number 9 of 2024 bracket election, stated to have been wrongly mentioned as FAO number 8 of 2024. He further stated that it is further stated that an OGLS appeal is pending in the appropriate forum. Since the matter is sub judice before the appropriate court in FAO number 8 of 2024.
9 of 1.
Oh, sorry, 9 of 2024. The petitioner is at liberty to seek appropriate remedy in the appropriate case. Therefore, we are not inclined to entertain this writ petition, which is accordingly dismissed. Next.
Item 2.
Item 2, my lord. That already instruction has been sought for. Today I have already discussed with the director. If they have 10 days time to, the common order was passed on 8.
All right. So 10 days you are.
How do you leave it?
So Aji, let us keep it on 3rd of March. You are getting
Okay.
sufficient time. The Land and Council for the state submitted that as per the order dated 21/11/2024, we seek some further time to obtain instruction. Matter. Put up this matter on 3rd March 2024. এটা গোটে করে লিখি দেবে along with
এই order basis ରେ ଆମର ଦେଇଥିଲା କାଲି।
okay. 2025. Yes.
Item 3.
My lord, BC, my lord. My lord, item number 3, 4, and 5 of Mr. Bhabansan Mishra. My lord, praying for an because I am praying for an adjournment. Item 3, 4, and 5. Now, poor next any day.
ଜାଣିଥିଲ?
Yeah, it was fine. That's some number.
You received the instruction?
Yes, sir.
ଭଲ, ତମର ବି ଭଲ।
14 ଉପରେ କଣ ନିଏ? Yes, sir.
କେବେ
1 is after.
ଚିନ୍ତାରେ।
the Learning Council for the state fixed for the time to obtain instruction in terms of the order dated 27/1/2020. The Learning Council for the Mr.
S.K. Mansi on behalf of
S.K. Manti, Learning Council appealing for the Vani Shankar Mishra also seek for an adjournment. Put up this matter on 3rd March 2025. Same order in Tinu Chari 5.
Item number 7.
6 for
Obligement.
Item 6.
In the last occasion,
Item number 6.
6.
Yes.
The commissioners have discussed sorry. Under the project cancel.
No. Have you got a copy of that order which we passed on 24/1/25? अच्छा ऐसे कुआड गला बोलो तो 24/1/25. Bala, please place that order. Place କରନ୍ତୁ କିଛି ଅସୁବିଧା ଅଛି କି ପ୍ଲେସ୍ କରିବା
matter is taken up
ତାପର ସେଇଟାକୁ ଛାଡି ଦିଅନ୍ତୁ ତାପରଠୁ ପଢନ୍ତୁ ହଁ
this petition has been filed by 135 petitioners with a prayer to direct the opposite party to consider the grievances of the petitioner on the annexure 1 series and for taking appropriate and necessary steps to include their names in the displaced person list on the project family for giving the rehabilitation benefit to the petitioner under the provision of LARR Act 2013 and guideline fixed for the Kanpur irrigation project. So far as annexure 1 series is concerned, we find that there are only 17 representations along with the postal district to show that it was submitted to the concerned authority. To put a portion to the Learning Council for the petitioner as regards the representation of the remaining petitioners, whether there is any documentation, they have also submitted representation to the concerned authority, and whether postal receipt in token of such filing of representation are available. Their answer is in affirmative, and the Learning Council submit that will file the copies of those representations with the postal receipt after serving copies thereof on the learning classes for the state.
So what happened?
We have filed also.
ଗଦେଇ ଦେଇଛନ୍ତି। ଏଠି କେତେଟା ପେଟିସନର ଅଛନ୍ତି?
We have filed it for
17ଟା ପାଇଁ
9 ଜଣଙ୍କର ଫାଇଲ କରିଛୁ।
ଆଉ ଖୋଜିବାକୁ ପଡିବ।
କେବେ ଫାଇଲ କଲେ?
ଆଉ ଗୋଟେ ମେମୋ ଅଛି। ମେମୋ
ଅଛି?
ହଁ।
ହଁ ଏଇଟା ଯୋଉ ଅଛି ଆଉ 110 ନମ୍ବର।
କପି 10
କପି ଦେଇନାହାନ୍ତି?
ଅଫିସ
ସେ ଆ ଭିତରୁ ଏବେ ଖୋଜିବାକୁ ପଡିବ ଆଙ୍କର ଅଛି କୋଉଠି।
ଆପଣ ପୁରା ଏକଦମ ଜଣ ଜଣଙ୍କର ନ କରିକିନି ଏକା 35 ଜଣ କପି ତ ଦେଇଦେଲେ ଆପଣଙ୍କର ପ୍ରୋବ୍ଲେମ ସଲ୍ଭ ହେଇଗଲା। ବାକି ଏଇ ଯୋଉ ଲୋକଟାଙ୍କୁ ସେ ଖୋଜିବେ କୋଉଟା କାହାର କଣ 135ଟା ରିପ୍ରେଜେଣ୍ଟେସନ ହେଲାଣି ତା ଦେହରୁ କୋଉଟା କଣ କାହାର ଖୋଜିବେ କଣ କହୁନାହାନ୍ତି? ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ଏଇ ଯୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ ବନ୍ସ ଟା ଦେଇଛନ୍ତି ଜଣଙ୍କ ନାଁ ଲେଖିଛନ୍ତି ସେ 135ଟାକୁ ଖୋଜିବେ ନା ନାଇଁ? ଆପଣଙ୍କର ସରକାରୀ ଓକିଲ ବି ଖୋଜିବେ, ଆମକୁ ବି ଖୋଜିବାକୁ ପଡିବ, କାରଣ ଆପଣ ପେଜ ନମ୍ବର ଦେଇନାହାନ୍ତି କୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ କାହାର ଅଛି କି ନାଇଁ ତାକୁ ଖୋଜିବାକୁ ସମୟ ଦରକାର ନା ନାଇଁ?
ପିଟିସନର ଲେଖିଦେଇଛି ପିଟିସନର 1 2 ଯୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ ଅଛି ତା ତଳେ ପିଟିସନର ନମ୍ବର ଇଣ୍ଡିକେଟେଡ ନାହିଁ।
ଓହୋ ଏମିତି ତ କରିଛନ୍ତି।
ଆଜ୍ଞା।
ଓହୋ
ଦେଖନ୍ତୁ ଆପଣ କପିରେ ଦେଖନ୍ତୁ ସମସ୍ତଙ୍କର ରହିଲା। ସେପାରେଟ ତ ଦେଇଥିଲେ ରିପ୍ରେଜେଣ୍ଟେସନ ବଢିଆ ହେଇଥାନ୍ତା, ଗୋଟେ ଗୋଟେ ହେଇକି କେତେ ସୁବିଧା ହେଇଥାନ୍ତା। ଆପଣଙ୍କ ସେଠି ସେ ପେଟିସନ ସାରିଲା ଇଏ କଲା ବେଳକୁ ହଇରାଣ ହେବେ।
ରିପ୍ରେଜେଣ୍ଟେସନ କିଏ ଡିସ୍ପୋଜ ଅଫ୍ କରିବ? ଆପଣଙ୍କର ପ୍ରୋଜେକ୍ଟ ଡାଇରେକ୍ଟର ମିନ୍ସ ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର
OP number 3.
OP number 3
ବର୍ଷେ ଦରକାର ହବ ତାକୁ ଆପଣ ଯୋଉ ଘାଟି ପକେଇଛନ୍ତି।
I may submit my let them to file individual application appraise in certain facility to the authorization.
ଆମେ ବି ସେୟା ଡିଫିକଲ୍ଟି ଟା ଭାବୁଛୁ ଯେ
ସେଇଆ କଲେ ହବ।
ଆପଣ ସେଇଆ କରନ୍ତୁ, ଆଉ ଗୋଟେ ଫ୍ରେଶ ରିପ୍ରେଜେଣ୍ଟେସନ ଦିଅନ୍ତୁ, ଇଣ୍ଡିଭିଜୁଆଲ ରିପ୍ରେଜେଣ୍ଟେସନ
including the order of this
ତା ଦେହରେ
ପୁରୁଣା ରିପ୍ରେଜେଣ୍ଟେସନ କପିଟା ଦେବେ,
ପୁରୁଣା ରିପ୍ରେଜେଣ୍ଟେସନ ର କପି ଆଉ ଯେ ସେ ଯୋଉ ଡକ୍ୟୁମେଣ୍ଟ ଟାକୁ ଯୋଉଟା ଦେଇଥିଲେ ସେଟା ଆନେକ୍ସ କରି ଦିଅନ୍ତୁ, ସେ ଅଛି ତ ଆପଣଙ୍କ ପାଖରେ ନା? that will be disposed of within a stipulated time. ଏଇଟାକୁ ଆପଣ 15 ଦିନ ଭିତରେ ଆପଣ ଦିଅନ୍ତୁ। ସିରିଏଲ କି ନ ହଉ
ସେପାରେଟଲି ଦେବେ, ଗୋଟେ ଗୋଟେ ଲୋକର ଅଲଗା ଅଲଗା ଦେବେ।
ନମ୍ବର 1 ପାଇଁ ରିପ୍ରେଜେଣ୍ଟେସନ, 2 ପାଇଁ ରିପ୍ରେଜେଣ୍ଟେସନ, ସେଇ ରିପ୍ରେଜେଣ୍ଟେସନ ଟାରେ ଏ ଯୋଉ 135 ଜଣଙ୍କର ସିଗ୍ନେଚର ହେଇଛି ତାକୁ ନ କରିକିନି ଇଣ୍ଡିଭିଜୁଆଲି ଜଣ ଜଣଙ୍କର ଗୋଟେ ଗୋଟେ ଦେଇଦେବେ। ହଁ ପ୍ରେସ୍ ଆପଣ କହୁଛି ପୁରା ପ୍ରେସ୍ ଦେବେ, 15 ଦିନ ଭିତରେ ଦେବେ, 15 ଦିନ ଭିତରେ ଦେଲେ ସେ ଅର୍ଡର ଟା ପାସ୍ କରିବେ, ଯେମିତି ସୁବିଧା ହବ। 135 ଜଣଙ୍କର
135 ଅଲଗା ଦେଇନ, ସେପାରେଟଲି ଦେଇଛନ୍ତି।
ସେପାରେଟ ଦେଇଛନ୍ତି।
ସେଥିପାଇଁ ମୁଁ କହୁଛି ଘାଟି ପକେଇଲେ।
Then what is the difficulty?
ନାଇଁ ଡିଫିକଲ୍ଟି ଯୋଉ ଏକା ହବ ଏକା ସାଙ୍ଗେ ଗୋଟେ ଗୋଟେ ହେଇକି ଅଲଗା ଅଲଗା ସେପାରେଟ ରିପ୍ରେଜେଣ୍ଟେସନ୍ସ, ତ ସେଇଟା ଗୋଟେ ଗୋଟେ ଅଲଗା ଅଲଗା ହେଇକି ଦେ ହାଭ୍ ଟୁ କନସିଡର ଗୋଟେ ଗୋଟେ ଲୋକର କେସ୍ ଅଲଗା ଅଲଗା ନା।
Individual case number initiate also.
ସେଇଠି ଅଲଗା ଅଲଗା ଗୋଟେ ଗୋଟେ ଫିଟିବାକୁ ପଡିବ।
case ଅଲଗା ଅଲଗା
ଗୋଟେ ଫ୍ୟାମିଲିର ଅଲଗା ହେଇଥାନ୍ତା, ସେ ଗୋଟେ ଗ୍ରୁପ ରେ କରିଥାନ୍ତେ।
और जो एलए केस वाला भी अलग
अलग ମାନେ ଲ୍ୟାଣ୍ଡ ଏଗନେଷ୍ଟ ରେ ଦେଲେ କେସ୍ ଇନିସିଏଟ ହବ ଇଣ୍ଡିଭିଜୁଆଲ,
ସେ ଫ୍ୟାମିଲି ହେଇଥାନ୍ତା ଗୋଟେ
ଆପଣ ଦେଖନ୍ତୁ ଲ୍ୟାଣ୍ଡ ନମ୍ବର ଅଲଗା ଥିବ, ତାର ଖାତା ନମ୍ବର ଇଏ ନମ୍ବର କେମିତି ଆପଣ ସିଏ ତାକୁ ଅସୁବିଧା ହବ। ଏଟା
ଡିସମିସ୍ କର ରିପ୍ରେଜେଣ୍ଟେସନ ସେ ଯାହା ବୋଲता है
separate with this petition has been filed paragraph 1 टा जोटा अछि order dated 24/1/25 तो सेटा टिपि देबे
ସେଟା petitioner ଲେଖା ହେଇଛି
135 as per the order dated 24/1/2025 the Land Council for the petitioner has filed the Xerox representation copies of annexure 1 in respect of 110 number for petitioner. However, after going through the same, we feel that it would be convenient for the opposite party number 3, na? Opposite party number 3, project director, Kanpur Irrigation Project. If
individual representation सफाई
if
individual representation
representation achieved.
नहीं enclosing the earlier representation particular actually application सेटा representation होने that is the application
ଆପଣ ଆଦେରେ ବି କିଛି ଲେଖି ନାହାନ୍ତି ଆପଣଙ୍କର ଯୋଉ ଲେଖିଛନ୍ତି ଯେ ମୁଁ ବହୁବାର ମୋର ଦସ୍ତାବିଜ ନେଇ ଆପଣଙ୍କୁ ଅନୁରୋଧ କରି ଆପଣ ସାଇକ୍ଲୋଷ୍ଟାଇଲ ଫର୍ମାଟ କରିଦେଇଛନ୍ତି ଆଦେରେ ଯୋଉ ଜମି ଯୋଉ ଯାଇଛି ଯୋଉଥିପାଇଁ ଆପଣ କ୍ଷତିପୂରଣ ମାଗୁଛନ୍ତି ସେ ଜମିର ଖାତା ନମ୍ବର କେତେ ପ୍ଲଟ ନମ୍ବର କେତେ ଏରିଆ କେତେ ଯାଇଛି ଏଗୁଡାକ ମେନସନ କରିବା ଦରକାର ନଥିଲା କିଛି ଦେଇନାହାନ୍ତି ଲେଖନ୍ତୁ in which the land acquired, the details of the land acquired of the respective petitioner are not mentioned. The Land Council for the petitioner, Council for the petitioner submits that a separate application will be filed for each of the 135 petitioners before the opposite party number 3, giving all the details within a period of 4 weeks दो 4 सप्ताह भितरे सब डिटेल करी दियो how with documents and in case the same is filed opposite party number 3 shall dispose of the representation in accordance with law preferably within a period of 6 months from the date of shift of the representation and communicate the order within 4 weeks
there is no
of the passing. Is made clear that we have not expressed any opinion on the merits of the case. Yes.
Item 7.
In this case, in view of the Civil Court's judgment case 17, Annexure 1, the NIC may be directed to acquire the land as per the rule.
Come to the order dated 21/25. Have you got a copy of the order? So that you upload आमे करूछु कोन पई
ना हम देखिथिली तो लॉजिक आज
देखिथिला आपण पूरा मन रही गला पूरा ऑर्डर रे कोन लखाई
my state council was directed to take
पढंतु ना ऑर्डर टा पढंतु
the writ petition has been filed by the petitioner so and so to direct the opposite parties more opposition 3 collector Noapada and 5 executive Kharia take immediately to acquire the land. That's the second parameter. The Land Council for the petitioner submitted that the petitioner initiated civil suit number so and so declaration of eviction at the executive Noapada Kharia district Noapada from the suit and the recovery of the damage and from the demand. The Land and Civil Judge Noapada by judgment letter data has been pleased to pass an ex parte decree against the defendant number 4 on contest against the order defendants and held that encroachment of land by defendant number 2 for the illegal and he was directed to evict from the suit land. It was further directed, it is open to the defendant number 1 and 2 acquire the suit land for the purpose of ministerial and row at career road at Furlong. The land and council of the petitioner further submitted after receipt of General Secretary. Government has made communication to the collector, district magistrate Nuapada, UP number 3, for furnishing the valuable information in that regard, for taking necessary action, even though the letter has been 13/1/2024, but no response has been submitted by the opposition member. Let the Land Council.
Status of the letter issued by the additional secretary to government to the collector, and whether the opposite party number 3 has passed any order or not, and whether any step has been taken for acquiring the land of the petitioner as per the judgment and order passed by the CS Hon'Ble.
We have sought for instruction that Parava is received on 1 week after. So
May I?
That order you have not challenged.
No.
Okay, so that order has reached finality. So now you are to acquire the land, pay the compensation, whatever it may be.
In fact, it was not in acquiring, but some area was acquired. But
Yes.
little instruction I have sought for the Parava is giving.
All right.
May I say one thing, sir?
If in order to that,
I
it
am
is
got
open
instruction.
to the opposite.
I am got
They have
instruction.
already taken steps.
I have got an instruction, Miller. The letter which your lordship has cited in the order, in the last order, that the annexure 3 page 20. The collector has not replied or not reported anything.
Only Paravai's comment received for selling is counter to the Bibli. Look, the London Council for the state submitted that he has already received the Paravai's comment and intends to file counter affidavit. कितने समय दरकार? Paravai
3 weeks time.
3 weeks time. 3 weeks time. February 10th of March 2025. Copy of the counter affidavit be served on the Land Council for the petitioner in advance. Yes.
Item 8.
Okay.
This is the case. My petitioner is removed from the job.
Where is it? Just a minute. Mr. Pari. Central Government. Union of India. You are there. Yes. Yes.
I am the central government.
इसे नहीं आदर S.S. Kashyap Central Government Council को ना लिखा है ना. Yes. What is this matter?
Matter is that my petitioner is removed from the job without any disciplinary action.
Your prayer is to quash the charge sheet and then order dated sworn of the London Tribunal. So you approach the tribunal. That is annexure. What is the order of the tribunal? 16/12/2024. Which is that order? Okay.
Page 158.
158.
I will draw your attention to page number 1.
163. Yes, para 5.
The order of disciplinary authority dated 8/10/2019 is placed on record at Annexure A/9, in which the disciplinary authority, after making detailed discussion, ordered as under. In view of the aforesaid discussions, it is hereby ordered that Srikant Chandra Sundar Rai, PA, Dhankanal HO, now under suspension, be removed from the service with immediate effect. This word B, the tribunal has given thrust. And secondly, but no evidence has been produced, nor it is the case of the respondent in the pleading or in course of hearing that any such order of removal was issued subsequent to the order of the disciplinary authority dated 18/10/2009. It is a well-known principle that once an order is passed after giving lawful consideration to matter, his duty or authority would come to an end. In other words, the authority concerned becomes functus officio in view of the above, the order of disciplinary authority does not the requirement of procedure provided under the rules. Thus, without any valid order, the applicant has been kept out of his rules. And para 6 letter part, my lord. But on microscopic examination of the order of the appellate authority dated 17/9/2020 and the order of the revisional authority dated 23/8/2021, we find that both the authorities rejected the appeal and revision referred by the applicant without considering the above aspect of the matter, that is, that the order of disability on the face of the language used therein is not an order of punishment in the eyes of law. Hence, it can safely be established that the order of rejection passed by the appellate and revisional authorities are without due application of mind. In the circumstances stated above, we refrain from classing the order of disciplinary authority because the said order is not an order of punishment in the eyes of law. But the orders of the appellate authority dated 17/9/2020 and revisional authority dated 23/8/2021 are hereby. As a consequence, the matter is remitted back to the appellate authority to reconsider the matter in accordance with law. The entitlement the applicant in view of observation and directions made above shall ultimately be abided by the order of appellate authority. He shall be passed within 45 days from the date of receipt of a copy of this order.
Yes.
My lord, once disciplinary authority, appellate authority, revision authority, they have used their statutory power. They become functus officio. Second one is, my lord, when the authority commits any mistake, he cannot take benefit of his work. Third one is, my lord, when the prayer is not made, any relief to be granted to the respondent without pleading or prayer, the tribunal has referred back the matter to appeal.
No, you see, suppose the appellate authority has not taken into account what he was required to do. That is the exact observation in paragraph number 6, that the appellate authority has taken into account all these aspects. So that is why the matter was, the order was set aside and the matter was remanded back to the appellate authority for fresh adjudication. So how you are aggrieved by that?
My lord, any statutory authority is obliged to perform his duty in a proper way. If he fails to do so, he will not get it. And I'm citing an order of Honorable Supreme Court.
You see, again, if the appellate authority order would aside, then what would remain? The order of the dismissal would remain.
Dismissal is not there. My lord, when disciplinary authority, appellate authority, revision authority, none of them perform their duty, statutory duty. They have committed a wrong. They cannot take benefit of their own wrong. And no statute provides that after that, anybody can punish my petitioner.
The respondents filed their counter affidavit that all reasonable opportunity has been granted to you, and after taking into consideration the allegation in the charge sheet, the report of the inquiring officer, the case of the applicant respondents, the punishment was imposed. Then the court when you filed this original application before the
My lord, I challenge
23.
My lord, I challenge
High Court.
High Court, my lord, I have but due to alternate remedy, it
Yes.
was remitted back and permission liberty was granted to file way in the learned tribunal. My lord, in way, I have predominantly prayed that the charge sheet issued by the authority is not completed. He is an ad hoc authority. And without considering that aspect, learned tribunal has given another direction that it may be remitted back. I never prayed, nor the respondent ever prayed that this is not an order.
Tribunal has the power to remit.
The main point is, my lord, the charge sheet, it is divided up, it is non-est in the eyes of law, considering the giving of enough case.
So that contention can be raised before the appellate authority. That contention can be raised before the appellate authority if that appellate authority has not taken into account all those aspects. That is the reason why the Learned Central Administrative Tribunal thought it fit to set aside the order of the appellate authority and remanded the matter
My lord, considering the
for reconsideration.
considering functus officio, now all
What
three
functions?
authorities, they have discharged their statutory duty.
Yes. Functus officio.
I have given citation.
What functus officio?
Pardon?
Who has become functus officio?
All the three of them.
Mr. Counsel, when the matter is remanded, he is empowered to deal with the appeal appraise.
My lord, once they have discharged their statutory duty, they have committed an error.
Suppose we decided an appeal and we passed an order. One party challenged our order in the Honorable Supreme Court, and the Supreme Court set aside our order and sent the matter to us for consideration, keeping in view all these things. So we are to freshly adjudicate the matter, or will become functus officio.
My lord, when the
Because earlier we have decided the appeal on merit. What is the submission you are making?
when the appellate authority, revision authority,
Dismissing the order.
they have considered
This
my lord.
writ petition has been filed by the petitioner Shrikant Chandra Sundar Roy. Challenging the order dated 16/12/2024 of the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00180 of 2023. The charge sheet dated 26/2/2016, punishment order dated 18/10/2019, appellate order dated 17/9/2020, and revision order dated 23/8/2021. With a further prayer to quash the charge sheet, punishment order, appellate order, revisional order, and the order passed by the Learned Central Administrative Tribunal, and to place the petitioner in the position prior to the initiation of the disciplinary action and suspension from service with consequential benefits to be notionally continued till the attainment of age of superannuation and benefits permissible on superannuation. The petitioner was working as postal assistant, Meramundali sub-office, The respondent number 5, Superintendent of Post Office, initiated disciplinary proceeding under section 14 of the PCS bracket CCA rules on the accusation that the petitioner had misappropriated an amount of rupees 40,000. Stop. The petitioner submitted his written statement of defense to the charge sheet. Whereafter, the proceeding in the proceeding, the order of punishment of dismissal from service was passed on 18/10/2019. The petitioner preferred an appeal against this order, which was rejected on 17/9/2020. Then he submitted a revision petition, which was also rejected on 23/8/2021. Thereafter, he challenged the proceeding before this court in WPC number 29443 of 2021, which was disposed of on 23/2023, giving liberty to the petitioner to approach the Land Central Administrative Tribunal. Whereafter the petitioner preferred the aforesaid way. After issuance of notice, the respondents filed their counter affidavit, wherein it was indicated that the proceedings was initiated and concluded strictly in accordance with, and all reasonable opportunities were granted to the petitioner. And after taking into account the allegation in the charge sheet, the report of the IO, the case of the petitioner and the respondent, punishment was imposed by the authority, which was duly confirmed by the appellate as well as the revisional authority. The petitioner filed the rejoinder to such a counter affidavit, wherein it is stated that taken by the respondents divorce the rules and principles of natural justice. The London Central Administrative Tribunal, after hearing the parties and going through the documents filed, came to hold that the disciplinary authority had order dated 18/10/2015. After making a detailed discussion, has passed an order that the petitioner was under suspension be removed from the service with immediate effect. It was further held that the order of the disciplinary authority does not meet the requirement of the procedure provided under the rules. And it was, and without any valid order, the petitioner has been kept out of the service. The London Central Administrative Tribunal further examined the order passed by the Appellate Authority on dated 17/9/2020 and Revisional Authority dated 23/8/2021 and found that both the authorities rejected the appeal and revision preferred by the petitioner without considering the certain relevant aspect as they were required to do, like whether the procedure laid down in the rules, Rule 11, has been complied with or not, and whether such non-compliance has resulted in violation of any of the provisions of the Constitution of India or in the failure of justice, and whether the findings of the disciplinary authority are warranted by the evidence on record, and whether the penalty imposed is adequate, inadequate, or severe. The London Central Administrative Tribunal held that since all these above aspects have not been taken into account by both the authorities, it can be safely said that the order of rejection passed by the appellate and revisional authority are without due application of mind. Accordingly, the London Administrative Tribunal has quashed was the order of the appellate authority dated 17/9/2020 and revisional authority dated 23/8/2021, refraining itself from quashing the order of the disciplinary authority. And remitted the matter to the appellate authority to reconsider the matter in accordance with law. With a further direction that the entitlement of the applicant in view of the observation and direction made shall ultimately be avoided by the order of the appellate authority, which shall be passed within a period of 45 days from the date of receipt of the copy of the order. The counsel for the petitioner submitted that since after disposal of the appeal, the appellate authority has become functus officio, the matter could not have remanded by the London Central Administrative Tribunal to the same authority for fresh adjudication, and therefore the charge sheet, the order passed by the disciplinary authority, the punishment order passed by the disciplinary authority should also be set aside, and consequential relief is to be granted. After hearing the London counsel for both the parties, we are of the view that the London Central Administrative Tribunal has given cogent reasons not only for setting aside the orders of the appellate authority as well as the revisional authority, but for remitting back the matter to the appellate authority for reconsideration of the matter, in as much as the appellate authority has not taken into account certain vital aspects which has been highlighted in paragraph number 6 of the impugned order. Therefore, we do not find any illegality or impropriety in the aforesaid order. Accordingly, the writ petition and dismissal.
Already petitioner attained the age of superannuation of peace charge 2020.
Mr. P.K. Padi and Mr. S.S. Kashyap. Yes, next.
Item 9.
That order was
Item 9.
Yes.
related to solve the problem. They have already solved. So you are in one to two.
You have the writ petition.
Yes, madam. I received.
Okay. So what is this writ petition, Mr. Mishra?
Question order 110 of CPC has been rejected by the learned executing court, that is Lara Sondal.
Which is the order you are challenging? 27/11/2024.
Miller.
Which is where is that annexure is?
At page 111.
Oh, yes. No, why have you given a type copy you do not follow? If
They have said this. Original I have
That's right.
learned court has issued this.
Okay. So what is the matter?
Another one suit, one agreement was executed between me, myself, and the opposite party.
No. In the operative part, it is mentioned
Yes.
that there is no merit in the claim of the petitioner, so and so. As such, the petition under order of 1 Rule 10 CPC is rejected.
Yes.
So, what was the original order passed by the?
That is not.
Can you explain?
May-
Can you explain?
May I submit?
Actually, I am the advocate in the lower court. Can I explain the exact matter?
May I
Yes.
submit?
My lord, what happened? This is a land acquisition case.
Yeah.
My land has been acquired,
Hmm.
and he is claiming that he's a farmer over my land.
Hmm.
But he has nothing to say such thing. So, so what happened? He filed a suit
Hmm.
before the civil judge junior division,
Hmm.
and again that suit has been challenged before the additional district judge, which has been gone against him. And
No,
now
civil suit order was passed. What order was passed?
civil suit order passed. No, he is the entitled person, which
Okay.
has been challenged.
You challenge that?
Yes.
Okay, then
Again, the order was against him.
Appeal was allowed.
Appeal was allowed. Yes.
Again, they filed a second appeal before this honorable court,
Yeah.
which is sub judice before this court.
Yeah.
Again, now this is they have filed this writ petition for the same purpose, for the same reason, for the same cause of action.
For claiming compensation.
Yes, ma'am.
Okay. So, Mr. Mishra, unless the
Submit on the.
yeah,
Present
just a minute. Is there any interim order passed in the second appeal?
second appeal.
It is sub judice before this court, he said. So because you lost the case in
Appeal.
so
And this one.
if that is the position, how will entitled to get the compensation?
Yes, I am submit. Will also be on to an exception.
The matter is sub judice before this court. Ultimately, suppose second appeal goes in your favor, matter is different. But if you have not got any interim order from in the second appeal, how when the appellate authority order is in his for his land, you will get the compensation amount.
There is an agreement between the parties. That is the agreement was for plantation of saguan trees in the land of the opposite party. That agreement was exhibited before the Land and Trial Court. And the indemnity bond has been filed before the land acquisition officer by the opposite party under Annex 3, stating that the claim, if any, that is 14 lakhs or more, that was exhibited under Exhibit 6. And suit has been declared. Award has been made, which is challenged by the state before this court. Lost against that.
What suit? What suit?
Not suit. Land acquisition. Thereafter, the preferred. That was also lost. The first appeal has been rejected on the ground that the suit is not maintainable. The London First Appellate Court authority has not dealt with the merits of the case. Simply said the suit is not maintainable. And so far the suit is concerned, neither he filed the refusal nor exhibited any documents, and they cross-examined me, and the suit has been declared for recovery of me. When the execution was filed by himself, in the execution I filed an application order 1. Compliance with that section 73, subsection 2 of the new one. That has been rejected.
That money has already been deposited with the other. So if it is deposited, then rather both of you have already entered appearance in that second appeal.
Yes, I have already received that money also.
So if he has received the money and the second appeal, it's all right. So second appeal, rather the prayer should be made in the second adjudication, so that if you are
this report directed the state government to take instruction. In the second appeal, without admission that it will directed the state government to take
That means it has not been admitted as yet.
No.
But you have filed the suit, now you have to wait. You are the person who filed the suit. So wait.
Suit has been declared. Suit for recovery of money, not that suit for claiming compensation from.
All right.
Because the entire amount, if he will receive, then question of substitution or to file a recovery.
So correct. He has received the entire amount. You are asking for recovery from him.
In view of the agreement.
Yes, understood.
Question is that that is to be decided in that ultimately in that second appeal or not. So how can you get the money at this moment? If he has taken the money and the second appeal order ultimately goes in your favor, and appropriate order can be passed.
Why it should be
liable? We do not know how much time the second appeal will take for adjudication. So we are disposing of that.
Taken of entire amount.
No, that is all
then
right.
I have to file another suit for recovery again.
Why? You have already filed. Why another suit?
Well, the suit has no relation with this land acquisition. Suit has a relationship only for recovery of money in view of the agreement.
So recovery of money of the land acquisition?
No.
Yes,
no. Kindly see the judgment of the London High Court at page 70.
The judgment which was passed in your favor.
No.
Yes.
Annex 7, page 50. Recovery of money of rupees 5,47,000. Start from page 51.
No, why recovery? Because it goes to the root of the matter.
Root is that agreement was executed, the land has been acquired. And my entitlement that I am entitled to get my share out of the Sagwan trees.
Who is the party? The opposite number 2. The land acquisition officer. This matter is a land acquisition case.
You have permitted him to plant these sagwan trees by way of an agreement.
Yes, my lord, that is admitted, but that has not been executed. On which time, after 10 years, they have to cut the sagwan trees, and after they pay some money to me, that has not been executed. And that is on a formal.
No, suppose land is yours.
Yes.
You are entitled to get the compensation so far as land is concerned.
Yes, ma'am.
But if you have executed an agreement with him
Yes,
that you plant the saguan tree,
yes, my lord. That
and whatever it would be the usufructs of that,
Yes.
or then that would be your, or this part of the share I will receive,
yes, my lord.
and you will receive this. Let us say this was the agreement. We do not know exactly what is the agreement. Then can you receive the entire compensation for those saguan trees?
No, for my
As per
land,
the
for my
agreement.
structure, and for the trees.
So everything you have received.
Yes,
His case is that so far as saguan trees is concerned,
yes,
since you have permitted your land to be utilized for the plantation
yes,
of the saguan trees,
yes.
and he has incurred heavy expenses for that, and how then you are not disputing that there was an agreement between the parties?
That I am not disputing, but that agreement has not been executed.
Not been acted upon.
Parted.
ଯୋଉ ଟାଇମରେ ସେଟା ହବାର ଥିଲା ସେଟା ସେ ଏକ୍ଜିକ୍ୟୁଟ କରିନାହାନ୍ତି।
ନାଇଁ ଯୋଉ ଟାଇମରେ ହବାର କଥା ନାଇଁ, ଗଛ ଲଗେଇଛନ୍ତି ନା ନାଇଁ?
ମୁଁ ଲଗେଇଛି, ସେ କେବଳ
That is
ତାକୁ
disputed thing.
Then
Also, disputed
writ
also.
petition, what can we do? Especially when the paisa neijayଛନ୍ତି.
Oh, they have taken.
So now it's a question of recovery.
Question of recovery.
So that is exactly what is your case in the also suit for. So
Suit.
it involves so many disputed things also.
That
What
is
is?
already- He has not filed the written statement. Now he is getting a double of.
No, we do not know whether the.
Suit ଉପରେ order दो.
No.
बस.
चलो वाला काम चलो.
So at this stage, this is not maintainable.
लिखो this writ petition has been filed. अच्छा लिख दो. As per the order dated 15. We are disposing of that. It is already sub judice. The matter is sub judice in the second appeal, which has got connection with this case. We are disposing of it. Yes, Lakhon.
To raise this question, because
You are always.
Raise this question, we will say ଆମର ଜଣେ
No, no,
High Court judge ବସିଛନ୍ତି, ଆମେ କହିବୁ ଏଗୁଡା ଏଗୁଡା ସେ decide କରିବେ.
Regarding this stay of execution.
This writ petition has, as per the
High
order
Court.
dated 15/1/2025, the learned counsel for the petitioner has already served copy of the writ petition on the land counsel for the opposite party number one. You are opposite party number one.
Yes.
Opposite party number one. It appears from the date chart submitted in this writ petition that there was an agreement executed between the petitioner and the opposite party, and where is the civil suit decree order? That's
Annexure 7, at least.
Annexure 7.
Miss Devi. कौन से थे? Gossiping.
And you are the and the petitioner filed a civil suit in the court of additional senior civil judge Salche on Go, which was registered as CS number 183 of 2017, and the present opposite party number one was the defendant number one in aforesaid suit, which was filed for recovery of an amount of rupees 5,25,804 and for other ancillary relief from the opposite party number one. The London civil judge by judgment and order dated 24/9/2021 has been pleased to see the suit in favor of the petitioner and against the opposite party number one, and held that the petitioner is entitled to receive rupees 5,25,804 out of the compensation amount received by the opposite party number one, along with the cost of the suit, and directed the opposite party number one to pay the aforesaid amount with cost of the suit to the petitioner within 3 months from the date of judgment, failing which the petitioner is at liberty to realize the same from the opposite party number one through process of the court. subpara. It further appears that the opposite party number 1 challenged the judgment and decree passed by the learned additional civil judge, senior civil judge Talcher in CS number 183 of 2017 before the
Additional district.
additional district judge Talcher in RFA number 8 of 2021 and by judgment and order dated 26/10/2024, the appellate court has been pleased to set aside the judgment and decree passed by the learned additional civil judge senior division Talcher in the aforesaid suit. The learned counsel for the petitioner submitted that challenging the order of the appellate court, the petitioner has preferred RSA number 441 of 2024 before this court, in which the Learned State Council has been asked to obtain instruction in the matter. All right. And you have also entered appearance in that civil
Yes.
the Learned Counsel for the opposite party number 1 submit that the opposite party number 1 has already entered appearance in the aforesaid second appeal, RSA. Since so far as the agreement, execution of agreement is concerned, it is disputed. And it is the contention of the Learned Counsel for the opposite party number 1 that agreement has not been acted upon. Be that as it may, since it is a disputed question of fact, and this court is in session over the matter in RSA number 441 of 2024, we are not inclined to this writ petition, which is accordingly dismissed. Yes. Okay.
Item 10.
Last petition, the lordship has directed learned BSCI to take instruction in the matter. Lordship, the order dated 29/1/2025.
Please come to that order.
Yes, madam. The petition
ଏଠି ହେଠୁ ପଢନ୍ତୁ କଣ ଅସୁବିଧା ହଉଛି କି ସେ ତ ବାହାର କରିଦେଲାଣି ଆଉ ସେଠି ପଢନ୍ତୁ ଛୁଆଇଛି ଆପଣ ମାନଙ୍କ ପାଇଁ ପଢନ୍ତୁ ବ୍ୟବହାର କରୁନାହାନ୍ତି
Yes, sir.
ହଁ କଣ
Petition Rudamendra Vishwal and Janak Balla Vishwal have filed this petition for quashing of the notice for eviction issued by the land acquisition officer Talimargarh NGB Rail Link Project East Coast Railway Sundargarh opposite partner 4 by notice number 115 dated 15/11/2024 under Annex 11 with further direction to Deputy Chief Engineer Construction 2 Talcher Talimargarh NGB Rail Link Project Sundargarh East Coast Railway Community Division opposite partner 5 to take necessary decision consequent upon issuance of the letter number 305 dated 7/8/2024 by the opposite partner of court. Learned Counsel for the petition drew the attention of the Annex 10, which is the extract of the order dated 7/8/2024 passed by the opposite partner of court. When it is concluded, while considering the representations of the petitioner as per the order of this honorable court dated 25/4/2024 passed in WPC number 42,220 of 2023, that the East Coast Railway is the apt authority to take decision in favor of the petitioners and hide letter number 305 dated 7/8/2024, the opposite partner 5 has been apprised of the case and the said authority was also subsequently requested to take necessary steps and decision in favor of the petitioner at an earlier. It is the contention of the Learned Counsel for the petition that even though such letter was issued on 7/8/2024 to the opposite partner 5, no action has yet been taken by the said opposite party. Rather, the petitioner has been sought with the notice of the eviction on 15/11/2024 filed in Annex 11. Since Learned PK Party Learned Deputy Solicitor General of India is
appearing for the East Coast Railway, opposite partner 5, let a copy of the petition be sought on him during the course of the day. Let Mr. Party, Deputy Solicitor General of India, obtain specific instruction as to whether any decision has been taken by the opposite partner 5 in pursuance of the letter number 305 dated 7, 8 issued by the opposite partner 4.
Yes, Mr. Pari.
I am appearing this case.
What is your instruction?
I have not received any instruction.
Have you asked for instructions?
Yes, my lord. The Laurent SGI submitted a letter to party for obtaining instruction, but I will.
Instruction is awaited, can say. So you want further time?
Yes, my lord.
Mr. Pari is there. If Pari is appearing with you or you are?
Allotted to me this case.
He has allotted this case to you.
Yes.
So how much time you require to obtain instruction in terms of that order?
3 weeks time.
Is it?
3 weeks time.
3 weeks time. So your name has not been reflected. You have that.
Have you given your appearance memo?
Yes. Appearance memo.
Also submits that as per order dated 29/1/2025, instruction has already been sought for, and 3 weeks further be granted to apprise this court about this development, if any, made in the meantime. Let this matter to the 10th of March 2025.
Okay. Madam, my name may be Himanshu Shekhar.
ଆପଣ ନାଁଟା ଅଛି ପରା
My name is there in the puzzle.
No, the name of
ଆଜି ବି
the.
ଲେଖା ହେଇଯିବ ହଁ
Yes.
It appears for the year.
ସେ ତ ଆପଣ first list ରେ ବି ଆସିଗଲାଣି. Yes, next.
In this case, the present petition is challenging the impugned order. Before doing that, I am submitting the brief notes for the kind perusal manner. Annexure 1 at page.
No, you just read the first paragraph of the impugned order of the Land and Central Administrative.
Yes, my lord.
That is at page number 22, running page, and the internal page is 2 of that order.
25, 24, 25.
Last,
we have considered the submission of the respective party.
Order pratham paragraph ta padhantu.
My lord.
The applicant has filed this way.
My lord. The applicant has filed this way, inter alia praying for a direction to the respondents to consider his case for regular promotion to the post of the SSO vacancies for the year 2011 by convening the review DPC with all consequential benefits, there being no criminal judicial vigilance in proceeding against him as per law by quashing the order dated 17/1/2018, Annexure A by 10, rejecting his representation. To direct the respondent to consider for regular promotion post of SSO vacancies for the year 2011 by convincing the review DPC as his case is sealed cover, because since there is no criminal judicial vigilance proceeding against him with consequential benefit, to pass any other and orders, my lord. Then the finding of the case, my lord, at page 6, at page 24. The concluding paragraph, we have considered the submission.
No, better you read paragraph number 5.
Yes, my lord. In course of the hearing, learned counsel for the applicant, by referring to the promotion dated 6/4/2015, has submitted that his immediate junior, Sri Pidapatri, was promoted to the post of SSO against the vacancy calendar year 2013, and therefore the applicant ought to have been promoted for the said vacancy year 2013 instead of 2014. Learned counsel for the respondents countered the said submission by stating that if the applicant has any grievance to the above aspect, he should have raised his grievance before the authority at the first instance, and therefore in view of the order dated 28/12/2021, this way has become infructuous.
What is the order dated 2021?
My lord.
Well, that is quoted here. The respondent issued the order dated directing as an order. During the pendency, respondent issued the order. Acha. Paragraph 3 रे लिखा है जिसे order टा quote है इसी.
Yes. My lord.
Just a minute. यार लोगों ना कौन जो जहाँ ना लिखा है चिट्ठी
Sri
Pidapatri.
ପକ୍ଷ ହେଇଥିଲେ ସେ ଓଏରେ ନା
My lord. That maybe. Sorry, my lord, but they are in fact.
ये जो
there is a-
order नहीं ये जो order टा पास है ला जोटा 28/12/2021 रे जोटा respondent issue कले ସେଥିରେ ପିଦାପତ୍ରୀ ବିଷୟରେ କିଛି କୁହାଯାଇଛି?
ସାର୍ ପିଦାପତ୍ରୀ ବିଷୟରେ କହିଛନ୍ତି ତାପରେ ମୁଁ ସାର୍
ଆରେ କୋଉଠି କହୁନାହାନ୍ତି ଆପଣ?
ସାର୍ ପିଦାପତ୍ରୀ ମାନେ ସେମାନେ ରିଭ୍ୟୁଡ୍ ହେଇଗଲେ as per the honorable high courts of Delhi high court order they revised ସେମାନେ 2014 ରୁ ଆସିଲେ that matter in order to bring before the learned cat a RA is filed before at annexure 25 and annexure 26 is the order which has been dismissed by the learned court learned tribunal on the ground that has been delayed. But the fact of the case is that his immediate junior due to the revised list of the in pursuance to the WPC number 1166/2006-2015 Union of India Jaising and others.
No, you come to paragraph number 6 now. You
Right.
order पढ़ुथिले. Now you come to.
We have considered the submission of the respective parties and perused the record, but we do not agree with the submission of the learned counsel for the respondent for the reason that since the respondent themselves issued the order of promoting the applicant with effect the date when his junior were promoted and order dated 6/2015 shows that his junior was promoted against the vacancy year 2013. The applicant is entitled to be promoted against the calendar year 2013 instead of 2014 as has been given to him. Accordingly, the order of rejection dated 17/1/2018 is hereby quashed and the respondent are directed to issue the consequential order of to the extent stated above within a period of 60 days from the date of the receipt of the copy of
So
this
what
order.
is the illegality in this order?
My lord,
You have given the promotion to him from 6/4/2015,
my lord.
right?
Right.
But, the junior was promoted in the year 2013. So that is how the
My lord, in order to bring
it
the
was held that
the fact, my lord,
yes.
there is a RA petition is filed before the learned court below to bring the notices. So in order to that, I have given a brief note to.
No, against this particular order which you are challenging here.
Yes, my lord. RA is filed, my lord, at annexure 25.
So we are disposing of that after RA.
Then that has been dismissed, my lord.
Then
on the at annexure 26 on the ground at page, my lord.
Have you
451, my
have you
lord.
annexed that? No question of annexation. You must have to take a ground that this is the respondent's development. If you say RA was that was dismissed, where is that order passed in?
My lord, at annexure 26, my lord, at page. The running page from 445 to 450, my lord.
When that order was passed? RA, no?
The order was passed on 27/2/2024, my lord.
Then how you have not challenged it? Because it has gone against you. You have filed that application for review, that review application, seeking of the review of that order which you are challenging here, and that has also gone against you because it has been dismissed. So are you not supposed to have challenged also that order in the writ petition?
Yes, my lord.
Then
both the annexure 1 and annexure
no, annex କରିଦେଲେ ହବନି ଜିନିଷ
annexure 26
ଦେଖନ୍ତୁ
ପ୍ରେୟାରରେ 26 ଟା ଲେଖିବା କଥା
ଆପଣଙ୍କ ପ୍ରେୟାରରେ କେବଳ ଅଛି to quash the annexure 1 that is judgment dated 16/11/2023 in OA number so and so.
Right.
So if against that order the central government has already filed a review petition which was dismissed, and obviously the order has gone against you, so are you not supposed to also incorporate that?
Incorporated annexure 1 and 26 should be written. Only annexure 1 has been prayer by mistake. But what is the cause of the action for review? Review, my lord. It is clear in paragraph 7. I have a brief note that on receipt of the judgment, the Ministry of
No. You either you amend the petition or will say that you have not your prayer
will amend.
Well, it is not only in the prayer. Nowhere else in the writ petition also you have taken that amendment. So amendment is required. Where paragraph 1?
Paragraph 1 ने नहीं चुन देखियो.
No.
Paragraph 1 में नहीं. That has been
खाली facts हिसाब रे written हेले कोन challenge है जो you have to take amendments.
I understand, man.
Look, this writ petition has been filed by the Union of India and the Director National Sample Survey Office challenging the judgment, challenging the order dated, challenging the order dated 16/11/2023 passed by the London Central Administrative Tribunal Cuttack Bench in 260/00095 of 2018, in which the opposite party Sujit Kumar Behera was the applicant, and the London Tribunal has allowed the original application filed by the opposite party and that and held that the opposite party is entitled to be promoted against the vacancy calendar year 2013 instead of 2014, as has been given to him, and quash the rejection order dated 17/1/2018, and the petitioners were directed to issue the consequential order within 60 days from the receipt of the copy of the order. Stop. During course of argument, the Land Council appearing for the petitioner submitted that against the aforesaid order dated 16/11/2023, the petitioners filed a review petition before the London Central Administrative Tribunal, which was registered as RA number 260/0004 of 2024, and had order dated 27/2024. The review petition has been dismissed on the ground of delay and laches. However, in the writ petition, the aforesaid order passed in the review petition has not been challenged. The Land Council for the petitioner seeks some time to file an interim application for amendment of the writ petition. Put up this matter in the recommencing from केबे रखिबा कोन अपन फाइल करिवे इंटरिम एप्लीकेशन कारण आपण ग्राउंड भी नेबाकू पड़िबो इंटरिम रिट पिटिशन ने प्लस प्रेयर पे अमेंडमेंट करिवे तेणु what time you require
Followed by 10.
put up this matter on 10th of March 2025 if an interim application is filed by the petitioner the same shall be placed on record yes etiquette but it will just coming within 2 minutes
Item 12.
Maybe. But maybe logic on this matter only chapter. The meantime, I will file an IA for correction of prayer. That is some inadvertently I have typed this is not part of
The land counsel for the petitioner seeks for an adjournment to file an interim application for correction of the prayer portion of the petition. Mr. Vani Shankar Raju, land senior panel counsel, by the appearance which is taken on record. Out of this matter,
1 week is enough.
Right.
2 weeks for it.
out of this matter on 3rd of March 2025. Interim application, if any. Huh?
କଣ ପାଇଁ କୁହାହେଲା ପରା ନାଟା?
Interim application, if any, be filed in the meantime, serving it for free from counsel for the
appearance memo ଦେଇଛନ୍ତି ତାହେଲେ ଅଟୋମେଟିକାଲି ଆସିବ।
second pause response.
Item 13.
In meantime, our amount is paid.
Yes,
In meantime, our amount only paid.
our amount paid. So this petition has become infructuous. All right. The land counsel for the petitioners, then since our amount has already been paid to the petitioner, the petition has become infructuous. In view of such submission, the petition is disposed of as infructuous. What is your good name? Jagabandhu? Mr. Jagabandhu Rao.
Item 14.
Yes, number maybe taken up one of the after will. I don't proceed.
What is your good name?
Gopinath Sethi.
Gopinath?
Sethi.
You have got no power in this case.
No.
Mr. Gopinath Sethi submits on behalf of Mr. Namutra for an agenda out of this matter. Arjun Gopinath did legal.
Item 15.
And then approved by Indian Law Association. The year 2003, next year, 1 minor.
No, you have submitted the representation
For the
before whom?
Chief Authority of IOC and the collector.
No, tell us that opposite party number 1 or opposite party 2?
1 and 2.
ये decide किए करियो?
ये decide करियो sen.
Minor 1.
1 decide करियो. 1 रो representation का है. Page number कितने?
21.
21 का. अच्छा, alright. तो केबे दले इटा को? Date का जरे कौन लिखा है नहीं?
412. The receipt
Postal issued here 412.
412 पे दले अच्छा.
That doesn't contain any details, Rush.
तो चलो
I mentioned the education of land.
What have you stated? Some lands acquired. Can we say page 15 for a minute? 15. Page 15. The petition claim has already been negated. Please, may I place it?
Yes.
Our reply. It is a reply under the RTI. As per the available land user records, the name of Sanjay Barik, Panu Barik, Susanta Barik, and Purnachandra Barik does not appear in the land user list provided by ITCO through IOCL. And this representation of page 20 and 21 doesn't contain much details.
Yes, I have mentioned the IOS project rehabilitation question about.
Your land details won't you mention because land has been acquired.
I have annex
20 have you mentioned?
Yes, madam. Running page 10, annex 1 minutes. My land is active.
Annex 1.
What do representation ti debe रिप्रेजेंटेशन रे लिखिवा उचित नुहे कि मोर आज्ञा जमी तार एई आयाता एतिकी जमी मोर आक्वेर आपण कर नै जंती मु क्षति पूरण पाइनी मते दियंती आपण लैंड डिटेल्स ता कोठी आपण को रिप्रेजेंटेशन रे उल्लेख करछन से विषय पचरा आउची आपण
Only when I have mentioned only abatement case number. I have no information how many land is accrued been, how many plots, my lord.
ମାନେ ଆପଣଙ୍କର ଯାହା ଲ୍ୟାଣ୍ଡ ଆକ୍ୱାର ଅଛି ଆପଣ ଜାଣିନାହାନ୍ତି କିନ୍ତୁ କମ୍ପେନସେସନ ମାଗୁଛନ୍ତି
There is the two plots. How many plots are accrued by the OP number 1?
आपण छडा बुझिबे ना एठी आसी केस फाइल कले केमति हो आपनकर को जमी आपण गोटे कंपेंसेशन आपण पाई प्रेयर करछनी परा आपनकर लिखिवा दरकार नै कि जानिबा दरकार नै मोर एई जमी समान कले सेति पाई मते कंपेंसेशन पाइबा दरकार मोर मते देई नाहंती आपनकर को एरिया रो को जमी अख्तियार कले गोटे कोन खाली रेंट अबेटमेंट केस गोटे कोन देई
Can see the running page 10, my lord. I have mentioned in Data number 32 in the that plot, my lord.
अरे एटा होची गोटे आरओआर रो कॉपी टे
My lord. That as well mentioned as IOC project abatement case mentioned, my lord. Page 10 is mentioned. IOC project abatement case number 10 by 3. तार मोट जमी 0.94 एकड़ को मोट 5700 से खर्च करा
अच्छा
सेचुरी लिखा है ए खाता किसी प्लॉट उपलब्ध है
ए जो ए खाता नंबर 32 और ये
यस
प्लॉट नंबर होची खाता नंबर 32 रो प्लॉट नंबर रे किछ नाही
खाली ओनली
एमती केम दियो
बिकॉज़ ता फॉलोइंग पेज ता देई नाहंती सतबे नाही
दैट इज द डिटेल्स वेंडर टू पेज इज आर टू पेज
आपण गोटे आरओआर इश्यू हबो ता देरे प्लॉट नंबर रहिबोनी ता देरे डिटेल्स रहिबोनी
नेक्स्ट पेज लिखा है ए खाता प्लॉट उपलब्ध नाही पेज नंबर 11
अब ते प्लॉट नंबर और चक्कर नाम कोन 7 8 नो दैट इज द कॉलम छाड़
अनस्टेड प्रॉपर्टी
एरिया भी तो नहीं एरिया भी दिया है
अरे ओनली इंफॉर्मेशन दे अबेटमेंट केस
the London State Council has pointed out from Annexure 2 जो ताकि कोनकरो RTI information asila जे as per the available land users record the names of apanokoro na that doesn't appear in the land user list provided by the input to the IOCL तो को basis रे आपण कहउछंती जे आपनकर लैंड एक्वायर हेछि बेली
आपण लैंड ता देले हमें कहि परिबी जे ताकर ए लैंड अछि इट इज नॉट इंक्लूडेड इन द लिस्ट बट ही सेज इट हैज बीन एक्वायर्ड ताले से कंसीडर करथा ले
19% से जानि दंडा द हाउ व्हिच मोडर केते जानि तो
हम जेतरा क्लाइंट आसुची आपण सारे कथावार्ता होची ए विषय रे आपण एटा फील करनाहंती जे गोटे प्रेयर करछंती हाई कोर्ट रे जे कंपेंसेशन पई ता पई कोन मिनिमम जिंस मते दबा दरकार रिपिटिशन रे so that जे कंपेंसेशन दबो से पुनी सैटिस्फाई हबो जे ई जमी गुडा को अख्तियार हेछि तार कुछ देबेनी केमति
move to court Tasildar and the IOC Paradip. But there is no such type of information. And in alternative is
thing is that a type ro order am जे करदबु रिप्रेजेंटेशन आपनकर रिप्रेजेंटेशन लैक्स डिटेल पर्टिकुलर से कोन रिप्रेजेंटेशन देखि कोन ता आपको रिलीफ देबे बा कंपेंसेशन केमति मिलियो आपण भाबुचंती जो रिप्रेजेंटेशन में किसी डिटेल्स ही नहीं खाली देखते मते क्षतिपूरण दिया जाए कौन क्षतिपूरण को जमी कौन जे किसी नहीं था देरे
पटा तो आर ओनली मेंशन द प्रोजेक्ट केस नंबर किसी डिटेल्स नहीं खाली खाता नंबर 32 एंड आईसी प्रोजेक्ट केस नंबर 7
ये आर को एनक्लोजर करि देई जंदी
माय लॉर्ड
यदि एनक्लोजर करि देई जंती आपनकर ए जो रिट पिटिशन जेतले फाइल कले whether it was not required to also annex those documents like Aadhaar card, ROR and form may be apne enclosure korichhanti with this representation.
Yes.
Why have you given the only that page, not the enclosures? It is a part and parcel of your representation or not?
Yes, sir. And
ଆରେ ବାବୁ ସେ ତଳେ ଲେଖିଛନ୍ତି ଆପଣ
my lord,
ସେଟା ଦେଇଛନ୍ତି ନା ନାଇଁ ପୁଣି
this my lord.
ଦେଇଛନ୍ତି ଏଠି କୁଆଡେ ଗଲା ଆମେ କେମିତି ଜାଣିବୁ ଆପଣ ଦେଇଛନ୍ତି ଆପଣ ଖାଲି ଲେଖିଦେଲେ representation enclosures ହଉଛି ଏଇଆ but that has not been annexed to that representation.
Are have annexed in
Annexed
ଗୋଟେ annex 1 କହୁଛନ୍ତି ସେଟା ସବୁ ଦେଲେ we would have sent that ମାନେ set ଯେ ଏଟା ଦିଆ ହେଇଛି ଏଗୁଡା ତା ଦେହରେ କିଛି ଇନଫର୍ମେସନ ମିଳିଯାଇଥାନ୍ତା କିଛି ନାହିଁ ଏଟା
date fix over here. Let them dispose of. Left on the petitioners Sushant Bari and Sanjay Bari have filed this requisition in the direction to the opposite party number 1, Chief of Indian Oil Corporation Limited, Paradip Refinery, to release the compensation amount against the land by the opposite party number 1 of the petitioner by reconsidering the representation dated 4/12/2024 with 3% interest per annum of the total amount in favor of the petitioners. Land Council for the petitioner submits that highlighting the grievances, the petitioners have submitted the representation under Annexure 4 series before the opposite party number 1 by post enclosing Aadhaar card, ROR by Khata number 32 of Mauja Kansari Patia and Form A of the information under Section 6(1) of the RTI Act. The postal receipt has also been annexed to the said representation. The Land Council for the petitioner drew the attention of the court to the ROR, which is under Annexure 1 series, where the Khata number has been mentioned to be 32, and it is mentioned that on the basis of IUC project rent abatement case number 10 of 2000, it was cancelled, and the plot number has not been allotted to the said Khata. That is your submission.
Yes.
All right. Total area টা লিখে দেবে 24 decimal. 24 না 94?
94.
94. If any such representation has been received by the opposite party number 1 with detailed particular as required, the same shall be disposed of in accordance with law and order passed thereunder be communicated to the petitioners. Here, from the let a copy of the order be produced before the opposite party number 1 for consideration of the representation. Yes.
But it's not aware of the plot variable.
The plot allot in
Petitioner not aware.
when we put a pertinent question to the Land Council query to the Land Council for the petitioner as to about the plot number, he pointed out from Annexure 1 series that in the aforesaid Khata no plot number has been mentioned.
ତାଙ୍କର ବ୍ଲଡ କୋଉଟା?
He has to give in the detailed particulars. The it needless to say that if the representation lacks detailed particulars, the same can be sought for from the petitioners, which will be provided by the petitioner. Yes.
Item 16.
Special railway project in the district of Sundargarh is includes land smeller, including the land of the petitioner. Now, during the land acquisition proceeding, the competent authority with opinion number 2 Mala, he has determined the compensation that is payable. Now, in the meantime, 19th of October 2024, Mala, I have been paid my compensation. Now, Mala, section 28 of the Railways Act, if I am aggrieved by that compensation amount or I claim a higher compensation, then I can approach the arbitrator who is appointed for the purpose.
Just a minute.
But you don't know the details of the arbitration.
Now, or they are providing me the award copy so that I can effectively make a challenge to that.
An RTA application has been made to that effect that is dated 18/1/2025. It has been annexed to the writ application.
The land house team, they are acquiring my land. So they are
Which one is?
The 20F subsection 6. 20 capital F subsection 6. If the amount determined by
Railways Act. 28.
20F.
Or 20F. Just a minute.
Capital F. Subsection 6. If the amount
6.
If the amount determined by the competent authority under subsection 1 or as the case may be, subsection 3 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government in such manner as may be prescribed. Now, under the rules, Land Acquisition Special Project Rules 2016, that LCB is holding the professional book, it will be at page 137. That rules.
Page 137.
Under sub-rule 3, the central government shall by the notification appoint an officer of the rank of a gazetted officer of the state government as arbitrator. My difficulty is that in spite of my several applications to the railways to provide me the award copy so that I can know the basis of determination of the compensation amount, they are not giving that. They are also
appearing for the rail. So why are you not providing the hard copy to him? He has a right to got it, so because thereafter he can take appropriate remedy if he is not satisfied. He can approach the arbitrator in accordance with law. So that is the simple prayer made by the. You obtain that copy of the award and so that it can be handed over to the Land Council, right?
And as well as the arbitrator who has been appointed.
Who is the arbitrator in this case?
Must be there in that agreement or where is it? Where?
Central government shall by notification. Notification no copy. Notification no copy de nahi asibe.
Copy of the award, copy of the notification.
Kahaku arbitrator hisab re. This writ petition has been filed by petitioner so and so. With a prayer for a direction to the opposite party number 2, that is Deputy Chief Engineer Construction, Southeastern Railway, to provide a copy of the award of compensation along with weight and valuation of the land, fees of the petitioner acquired by the railways, and determined under Section 20F (1) of the Railways Act 1989 pursuant to the notification dated 19/8/2024, and the details of the arbitrators appointed by the central government in terms provision under Section 20(f)(6) of the Railways Act, enabling the petitioner to invoke arbitration. During course of argument, the Land Council for the petitioner placed Section 20(f)(6), which reads as follows. He further placed Rule 3 of the Land Acquisition Special Rules 2006, which reads as follows. एक हमें ये कर दीजिए बॉयल फोल्ड कर दीजिए ना 16. The Land Council for the appearing for the Union of India seeks some time to produce the copy of the award of compensation. So also the notification issued by the central government, if any, for appointing the arbitrator in consonance with Rule 3 of 2016 rules. List this matter. केबे रखिबा कोन मैडम 3 तारिख रे रखले चलिबो 3rd of March 2020. Appearance memo filed by Mrs. Shefali Das for the Central Government Council is taken on record. Name of the Land Council be reflected in the first list and scope. Is it a full for the issue?
Item 17.
Similar order.
फोर टा टिके देखिले अधा तो ब्लैंक छाड़ देई जंदी तो जे एप्लीकेशन आपन का तो नो एनेक्स 3 इज द एप्लीकेशन 4 इज योर रिप्रेजेंटेशन फॉर्म दउ जंदी extent of land no from agriculture other sources common address 9 is page 21 2021
Annexure 4 of
representation
Annexure
there is no proof of
4
possession of remark annexure 4 टा देइचंती कोटे acknowledgement हला कि postal receipt पर से
दियन तो पोस्टल रिसीट दियन
postal receipt अछि केमती जानिबा आपण सबमिट करछंती बोली तहसीलदार आउट
6 दिन आगे रोड सेक्शन तैयारी करते हैं रिक्वेशन जो रखिले
आपण एटा 4/2/2024 रे फाइल कर देले अब ये रीट टा केबे फाइल करले
तैयारी करते
चारि दिन समान दिन
तो सेही दिन एठी फाइल कर दे एठी चलेले रिप्रेजेंटेशन डिस्पोज ऑफ करे आपण 4/2 केबे 24 रे अच्छा एटा रीट पिटिशन दा फाइल 25 रे ओके but you have got no proof that with you that such a representation has been submitted except that document which you have filed. There is have you abhorred in the writ petition that when you submitted that representation under annexure before the authorities, representation date ta hochi 4/2/2024 केबे ताकू देले को प्रोसेस रे पठेले हाथ रे नहीं देले कि पोस्टल रे पठेले
पैराग्राफ 13
हां पैराग्राफ 13 लिखि जंदी
ना लिखि न
पुनः अप्रोच कले भी नहीं खाली अनेक्सेट टा लिखा गेला कॉपी हमरा
वर्तमान हमें ऑर्डर टा पास करिवु से एप्लीकेशन थिबो नथिबो को दिन देइचंती तार किछि प्रूफ भी नहीं से कोन खोजिबे कोड मिलिबो ता पर रिप्रेजेंटेशन आपन करो इंक्लूडिंग
ट्रेस दियो ट्रेस
petition has been filed by the petitioners inter alia for a direction. आपन representation होची annexure 3 लिखछन्ती that annexure 4
application form 1
for disposal of the representation under annexure 4 or 3 Tahsildar Owl. The Land and Council for the state has raised a preliminary objection that there is no proof that the annexure 4 dated 4/2/2024 has been submitted to the opposite party number 3 and he submits that the petitioners should be directed to file a fresh representation in accordance with law. The Land and Council for the petitioners also submits that a fresh representation containing all the details will be submitted before the opposite party number 3. If any such representation is submitted, the detailed particulars before the opposite party number 3 by the petitioners, the same shall be considered in accordance with law. Yes, next.
Item 18.
We have filed the certified copy of the Annexure 7 that
Miss case number 115 of 2016 for dispensing with certified copy of Swanson. Application has been filed for dispensing with the certified copy of Annexure 7. The Land and Council for the petitioner submits that he has filed the certified copy of Annexure 7 and therefore he does not want to press this miss case. Accordingly, miss case is disposed of. Where is that Annexure 7?
That I have filed in, this is the receipt I have filed in. Today I have filed.
वो आज ही फाइल कर दिया कोर्ट रे फाइल कर दिया
ना कोर्ट रे करनी
he has already filed the Swanson with him on 13/2/2025 एटा पर एठी दोजन Annexure 7 टा सर्टिफाइड कॉपी और सेठी कोन फाइल कर वो आणि मगई देले he has already all right.
My lord, this is a case of the year 2016. It is not available in LMS as well also file not available.
ना notice issue है नहीं. Notice issue है नहीं.
ताको पाखरे टोटल फाइल नै अपन ओटे कॉपी
मो कॉपी नो if your lordship will issue notice I will
आ कॉपी टा दियौ तो
हां दे देबी
एडवांस कॉपी गोटे देबे
हां दे देबी
दियौ केबे देबे
by tomorrow.
Mr. Land Council appealing for the petitioner submit that the entire copies of the CRLM key.
That is a defect. Once you serve copy, defect can be removed.
We served on the Land Council for the state by tomorrow. Put up this matter on next week. Yes,
2 weeks for
2 weeks
for admission.
So put up this matter in the week commencing from 3rd of March.
Public. For admission.
Yes.
धन्यवाद
March 20. आउ किसी डिफेक्ट नहीं तो
ना कुछ नहीं से Annexure 7 थिला और कॉपी सर्विस में
yes next.
Item 19.
Union of India.
Mr. Padi.
My lord, I'm sorry. In fact, that is allotted to Mr. M.K. Pradhan, Mahendra Pradhan. Perhaps he's not there. I will intimate him. Kindly be taken up any other day.
Right. The mention is made on behalf of the Union of India for adjournment. Put up this matter. 3rd of March 2025. Yes.
Obliged.
Item 20.
Remove the defects and the meanwhile, Mr. Kashyap, tell the
Yes, my lord. Yes, my lord. I'll intimate.
Defects shall be removed. Defects are pointed out by the stamp. Yes.
Item 20.
Item 20 should ask you 2 items. I have no instruction because just a minute. First two item Alok Kumar and Saroj Kumar there. Okay. But Deepak and Subras I appear. Total instruction নাই আগে কোনটো এটা মেমোতে দিয়ন্তু নো ইনস্ট্রাকশন দেলি 2799 দুইটি কাগজ দিয়ন্তু the Mr. Sanjay Kumar Samantraya, Land Counsel for the petitioner, files a memo that he has no instruction in the matter. The memo is taken on record. Accordingly, the writ petition WPC number so on is disposed of. Interim order কিছু আছে তাদের?
Yes,
interim order. Disposal করে এটা কোনটা এটা যাইଥିଲା সেটি যে
ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଟା କାଲି ଯୋଉଟା ଡିସ୍ପୋଜିସନ ଟା ଥିବ ଦେଖେଇଦବ
ଗୋଟେ ହଉଛି ନେକ୍ସଟ ଆଇଟମ ଦିଟା ଯାକ ମେମୋ ଦେଇଦେବେ
ଆଉ ଦିଟା ମ୍ୟାଟର ମୁଁ କହୁଛି 13069
କୋଉଟା କୋଉଠି
ସେଇ
ତାର ଦିଟା କନେକ୍ସନ ଅଛି
13069
ଟିକେ ସେଟା କୋଉ ପେଜ ରେ ଅଛି ପଜ
ପାର୍ଟିର ନାଁଟା କରିଦଉନାହାନ୍ତି
130
ପାର୍ଟିର ନାଁ
ରୁଦ୍ରମୋହନ ପ୍ରଧାନ
ସେଇଟା ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ବୋଲି ଲେଖିଦେବ ମେମୋଟି
ଫାଇଲ ନାହିଁ ସେମାନେ ହଇରାଣ ଜଣା ପଡୁନି
ନାଇଁ ନୋ ଇନଷ୍ଟ୍ରକ୍ସନ ଖାଲି ଗୋଟେ ମେମୋଟେ ଦେଇଦେଲେ ହେଲା ଆସୋସିଏଟ କୁ କୁହନ୍ତୁ
ଆପଣ ଏକା କଥା ନା
ସେ କିଛି ଟର୍ନ ହଉନି
ଟର୍ନ ଆଉଟ ତ ଆପଣ ଦେଇ ଦଉନାହାନ୍ତି ନୋ ଇନଷ୍ଟ୍ରକ୍ସନ ରେ ଆସୋସିଏଟ କୁ
ବଟ୍ ଆପଣ ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ଚିଠିଟା ଦେଇଥିବେ ନହେଲେ ଆପଣ ନାଁରେ
ତାପରେ ଏଇଟା ହଉଛି ଏଇଟା ଡିସ୍ପୋଜ ଅଫ ହେଲା ଆଉ ଗୋଟେ କୋଉଟା
13070
ତାପରଟା ଦିଟା ମେମୋ ଆସୋସିଏଟ କୁ କୁହନ୍ତୁ ଯାର ପାୱାର ଥିବ ଲେଖିଦେ ମେମୋ ଟେକନ ଅଛି ଚାରଟା ମେମୋ ଟେକନ ଅଛି ଫର ଡିସ୍ପୋଜ ନାଇଁ ଏ ଦିଟା ଲେଖିଦେଲ ନା ପ୍ରଥମ ଦିଟା ଆଉ ଗୋଟେ ହଉଛି ଏ ଯେ ପେଜ ନମ୍ବର 6 1306 ଆଉ ଗୋଟେ ହଉଛି ତା ପରଟା 13070
ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ଚିଠି ଦେଇଛନ୍ତି ତ ସେ ପରେ ଆସି ଆପଣ ଧରିବେ
ହେଲା alright next
ରୁଦ୍ର ପ୍ରଧାନ ଯେ ସେ ମରିଯାଇଛି
ତାପରେ yes Mr. Samantraya you place the case 2801 ଟିକେ ରୁହନ୍ତୁ yes in this case the petitioner is a bona fide purchaser matter but the lease was granted in the year 1959-60 under annexure 1 the ROR itself reflected till 2010 no cancellation no review nothing else no you are challenging the ex parte order dated 5/10/2013 yes madam under annexure 4 yes. In appeal case number 1362 of 2013 yes. Where is that order? Let us see on the annexure 4 to page 25 is a same ground of your lordship can you see following OJC 944 of 1993 whether it is utilized or not କାଲି କେତେ ନମ୍ବର ଥିଲା ଆପଣଙ୍କର ଅଛି ଅର୍ଡର ଟା କାଲି ଗୋଟେ ଏଇ ଟାଇପର ମ୍ୟାଟର ନଥିଲା ଆମେ what is the number of that କାଲି ସେଟା ଥିଲା WPC number ଦେଖୁନ 24 second item setting or 2798 এটা 2798 2014 সেই তাদের भी स्टेटस को ऑर्डर का भी एक्सटेंशन नहीं चाहिए था तो सेम ऑर्डर टाइप पास होची जो ताको देखि देबा अपन चांस परिवार की बहुत है ऑर्डर खाली डेट का दे देबा आज रची 9 2014 सेटर के पेजी बाकी इंटरिम ऑर्डर जोटा मिस केस नंबर टा इटा
ଏଟାରେ LCR ଟା ଆସିଛି not received second ଟାରେ ଆସିଛି ଦେଖ ଦୀପକ କୁମାର ସାମନ୍ତରାୟ ଆସିଛି LCR in 1362 ଏଟା ଟିକେ ଚେଞ୍ଜ
तो कॉपी के बाहर कर कौन चेंज हो गई Yes, similar order is to be passed like yesterday. This in this matter.
The petitioner got the land as per the agreement taken in the requisition paragraph 3 to 7 miles, 3 to 6. Last time you were also how did
Daki chalo da wo. जो काली का जो order है, ये गवर्नमेंट देखी तो नहीं लिखा है तो जैसे प्लॉट नंबर भी अकाउंट को चेंज है ये 3 4 5 ଆଉ ଗୋଟେ କୋଉଟା କହୁଛନ୍ତି
up to 6
ପର୍ଯ୍ୟନ୍ତ 3 4 5 6
the second subject
ସେଠି ଗୋଟେ ଦେଇଦେଲେ ବି ଟିକେ ସୁବିଧା ହୁଅନ୍ତା ଗୋଟେ
ସେ ଅର୍ଡର
କାଗଜ ଗୋଟେ ଦେଇଦେଲେ ବି ଟିକେ ସୁବିଧା ହୁଅନ୍ତା
ସେ ଅର୍ଡର ଯଦି ବାହାର କରିକି କେମିତି ଲୋକ ଯେମିତି ସୁବିଧା
the petitioner was mutated.
just a minute.
Here is no mediation.
ଆପଣ ଅର୍ଡର ଟା ଅପଲୋଡ ହେଇଛି ବୋଲି ଜାଣିଛନ୍ତି ନା ନାଇଁ କାଲିର ଯୋଉ ଅର୍ଡର ଟା କିଏ ଖୋଜିବ ତାକୁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଏଇଟା ଚେଞ୍ଜ ହବ ସେ ଅର୍ଡର ଟା ଆଣିକିନି ପେନସିଲ ବୁଲେଇକି ଲେଖି ଦେଇଥିଲେ ନା
Actually, ମୁଁ ଚେକ୍ କରିଥିଲି ସକାଳେ
କରିଥିଲେ
ଅପଲୋଡ ହେଇନି ବୋଧେ ଆସିବୁ
ନମ୍ବରଟା କାଢିଦେଲ
ଏଇ ନମ୍ବରରେ ବାହାର କରିଦେଲ କାଲି ଅର୍ଡର ଟା ଠିକ କଣ ସେ WPC करो 2798 of 2014 ऑर्डर अपलोड ही नहीं कौन
ମୁଁ ଫାଷ୍ଟ ଅର୍ଡର ଚେକ୍ କରିଥିଲି
हाँ दियो बाहर प्रिंट कोड बाहर कर दो
କାଲି 6ଟା ବେଳେ ଅପଲୋଡ ହେଇଛି କେମିତି ଆପଣ ଆଜି ପାଇଲେ
सब टाइम एटी अछि
ମୁଁ ନିଜେ
इंटरनेट अपडेट करना दी बाकी रही कि BSNL कंपनी रो ना
ନାଇଁ ଦିଅ
जियो
ଯାହାହେଲେ one has to verify personally
BSNL ଗଭର୍ଣ୍ଣମେଣ୍ଟ
आपण एटा को रखंतु जहा जो डेट से नंबर कोन जहा चेंज हबो आपण करि कि नहीं देबे बुझिले
ଗୋଟେ ଦେଲେ ଜେରକ୍ସ ସବୁ ରେକର୍ଡ ହବ ପାର୍ଟିର ନାଁ କେସ୍ ନମ୍ବର ସବୁ अच्छा म्यूटेशन जदि रहबोनी सेटा काटी देबे
এইটা করে দিচ্ছি এইটা করে নিয়ম ইয়েস
केबे को जाइए सेटा देखले सेटा देखि अच्छा
এইটা কি করবেন 7th April नेक्स्ट कुहतु 2802
अच्छा काली रो से एका पिटिशनर
Here, petitioner also bona fide purchaser.
यादर कौन अपन चैलेंज करछंती
Three orders matter.
वेट
Matter six the purchaser.
Then apart from that appeal case,
Annexure 8 series.
apart from that appeal case, you are challenging also the orders passed in that rent case.
মানে অপিলের রেট আর অবজেকশন দুইটা কো চ্যালেঞ্জ
And upon prayer portion, also you have mentioned that to set aside the order in that rent case, then order in the appeal case, এগুলা তো সব মধ্যে
না appeal pending ଅଛି
application না না appeal भी appeal case থাকলে under annexure 9 and the rent and what happened my lord I have filed objection because the land was recorded in favor of the purchaser. So, where the seller, vendor. So I have filed my objection. But on behalf of the ASO himself, without observing and without any taking any steps under Annexure 8 series, he has created so motor proceeding and so motor proceeding. সেটাকে পাঠাই মো রেট অবজেকশন টাকে লিখে দাও পেজ 64 লর্ডশিপ ক্যান সি by the order sheet in rate objection case number 10143 10147 of 2013 that is the sum of rate objection initiated by the state government against the Jogi telling the same. So, in favor of which the land was thereafter I preferred appeal. And the appeal in the self and ground was
से तार आउ गोटे कॉपी करिकिनी तादेर जो ऐड हबो यादेर किछि अधिका जिंस रहिबो सेटा को मध्य पेंसिल ले लिखि दियंतु इनकॉर्पोरेट हैला ठीक है बेबी 7/4/2025 या से जो WPC नंबर ठीक है यस तापरे WPC 5876 of 2014
So far as this particular case is concerned, the petitioner is similarly placed to Narottam Ratho for the petitioner in the deed case, because we are both purchasers from the same vendor. In whose favor the valid lease has been.
That order was passed.
We are also seeking the status of the appeal file. Here also appeal has been filed.
Okay.
Last occasion, that is the giving the appeal number.
See order is issued.
Commencing 3rd of March. I made correction in the objection case.
এই অর্ডারটা পাস করিয়ে এটা আচ্ছা এটা নরোত্তম রথ এগুড়াক ବି ସବୁ গোল বুলেই দেওয়া কথা
আরে না গুড়া ବି ଚେଞ୍ଜ
ନା ଗୁଡାକ ଆଉ ସେ ରିଟ୍ ପିଟିସନ ଏଗୁଡା ଦିଅନ୍ତୁ ଚେଞ୍ଜ କରିକି
କରିଦିଅନ୍ତୁ ସେଟା ଭୁଲ ହବନି
ହୁଁ
8637. So far as 8637 and 8530 is concerned, I have already intimated, and they have taken the file from the SL. The matter has been referred to the Supreme Court. So I gave some time to
What?
Supreme Court पर dispose of करेंगे
dispose of this file का नहीं है इसको return नहीं है तो certificate signing देना है. I have already instructed them. And so far as 88829 is concerned.
No, ये गोटे कौन 8637 adjournment
मालो
केवे रखियो
first week of March. Can I say Supreme Court आने की जगह 8637 and 8830.
8830
मालो
नहीं गोटे
8829 ଟା ଅଛି
8829 ଟା ସେ already କହିଛନ୍ତି ଆସି ଦେଇ ଦେବେ ବୋଲି ମୁଁ full instruction ନେଇ
तीनटा तो जीवो
ତିନିଟା ଜାଗା
So land council for the petition 6 for an adjournment for 2 weeks matter to be displayed on 3rd March 2025. इगोला तीनटा तापर आसला
already entry model there.
एंट्री मॉडल अच्छी
I get it. Absolutely.
एंट्री मॉडल है 16/5 एंट्री मॉडल dated 16/5 जो थे जाती है list case number so on so will continue till next date. Yes,
all right.
next date लिखी दो
2025 में till next year एंट्री मॉडल to continue till 3/3/2025 ये जो तीनटा मैटर है এটা কোন ପାଇଁ ଅଛି
এটা হিয়ারিং ପାଇଁ ଅଛି ମୁଁ ଫାଇଲ କରିଦେଇଛି ରିଟନ୍ ନୋଟ ଦେହ ବହୁତ ଖରାପ ଦେହ ଖରାପ ଅଛି ମୁଁ ଆଇ ଏମ୍ ଅନଏବଲ୍ ଟୁ
apparent custody ଅଛି
କଷ୍ଟଡିରେ
ହଉ ତାହେଲେ ଆସନ୍ତା ସପ୍ତାହ ପାଇଁ ରେଡି ହଉ
ଆସନ୍ତୁ
ଠିକ ଅଛି
ମୁଁ ରିଟନ୍ ନୋଟ ଅଫ ଆର୍ଗୁମେଣ୍ଟ ବି ଦେଇ ଦେଇଛି
yes
May pardon, madam. It was coming in the hearing list, madam. It is delisted, madam.
कौन सर नंबर कितने
640 of 2012, CRLA.
CRLA
Yes.
देई दियंतु रजिस्ट्री को देई दियंतु सेठी कर देबे से
Of that.
yes
Supplementary list, item number 1.
Yes, my lord. My lord, here petition is languishing in jail custody since 16/7/2013. Sorry, 26/7/2013. Though the incident also occurred on 16/7/2013, the FIR was lodged after 10 days. My lord, the allegation, so far the allegation is concerned that
how many times it's a CRLA just a minute
I will reject thinking.
I will reject
no
first time was yes
first time yes first time sir. 12 years in custody.
Yes, sir. Forward ହେଇଛନ୍ତି 26/7/2013 ଆଚ୍ଛା
ଇନସିଡେଣ୍ଟ 16/7/2013
କୋର୍ଟରେ ଆପଣ ବେଲରେ ନଥିଲେ
नो
ଦେଖ this person is in custody ଆଚ୍ଛା ଠିକ ଅଛି so କଣ ଅଫେନ୍ସ କଣ
302 allegation is killing my son infanticide creating doubt
inside the
infanticide
oh Why you have killed your son?
Because creating, suspecting the paternity.
Oh, paternity.
Yes. 1 month child was also
What
killed.
the age of this child?
1 month. 1 month. 1 month.
So who has stated against you?
Only wife, the PW say 6.
PW 6.
6. No eyewitness.
Who has stated?
Yes.
What he has stated? No.
Sir, we read out the statement.
PW 6 evidence achi.
Yes, yes. That is it. Accused Uddhava is my husband. We are blessed with 4 children out of.
Trial court record.
Yes,
Yes.
Sir. Sir. Accused Uddhava is my husband. We are blessed with 4 children, out of whom the last one is dead. My last child was male one. My last child died within 1 month of his birth. Last year in the month of Asada, on a Tuesday at about midnight, my husband accused, disowning his paternity over the last male child, killed him by pressing his throat in my presence at home. The deceased child was called in the name Vijaya. That child was killed by the accused within 1 month of his birth. The accused threatened to kill me if I disclose the incident to anyone. In the next morning, my husband, with the assistance of some villagers, buried the dead body of my child. As I apprehend danger to my life from the side of my husband in the following Thursday, I left for my maternal uncle's house along with my mother, along with another son and daughter. I resided at the maternal uncle's house in the village Tendaguda for about 8 days.
So obviously there is no postmortem here.
No, there is a postmortem. PW7 has also conducted.
Dead body dispose kala pare.
Postmortem was there. They conducted. PW7 next. Doctor. Sir. PW2 says, sir, PW2, PW2 says, sir, PW2, the accused is my own elder brother. He was blessed with 3 sons and 1 daughter. His third son of 11 days old died in the month of Asar. That kid was named as Vijaya. We buried the dead body of that child in a burial ground for our village. I do not know if my elder brother killed his third son. Police team recovered the dead body of that child in the burial ground. There was no sign of any injury on them of that child. Cross-examination that the child died due to illness.
PW7 जो डॉक्टर जो कହୁची
सर
strangulation claim 10 to 12 days aguru death age ତାଙ୍କର report ଦଉଛନ୍ତି.
Yes.
So paragraph 2 here of PW7.
Paragraph 2 तो of PW7.
The cause of death of the baby occurred due to the asphyxia, which is further due to throttling. The duration of death from PM examination was 10 to 12 days. Accordingly, I prepared the autopsy report. The autopsy report is on side.
11.5 वर्ष रहिलेଣି.
Cross examination to
Do one thing, you obtain the status of the other children, 3 children, and also the wife of the who is examined as PWS and custody certificate. All right. This case number 1436 of 2015 is an application for bail. The Land Council for the state submits that she has not been supplied with the deposition copies. Let the Land Council for the appellant supply the deposition copies to the Land Council for the state. The Land Council for the state shall obtain the custody certificate of the appellant from the concerned jail superintendent and also an instruction regarding the status of the wife of the appellant. That is Chanchala
Chanchala Mundagudia.
who has been examined as PW6. So also the children of the petitioner and PW6. Put up this matter on such and so forth. Third of March. Yes.
Item 2.
Engagement provider.
Admit being admit corporates.
Admit
that is order dated 10/8/2015, order number 3. Prior board report की कौन सी चीज है बोला engage कर दो
लिस्ट दियंतु रे लिस्ट बारे कोन एते कल्पना ओकिल के नाहंती दस सेतबेले 8 ହେଇଥିଲେ ଏବେ 10 ହେଇଯାଇଥିବେ କରିବେ ତ ମାଡ ବି ଦେଇଛନ୍ତି ପତ୍ର କହିକି ତ ଦେଇଦ ହଉ
Yeah. Prisoner's petition has been received for engagement of an advocate. Mr. Samir Kumar Mishra, and senior advocate, is engaged as the amicus curiae for the appellant. Office is directed to prepare the paper. Intimation be given to the appellant, so also to the senior advocate. Yes.
Item 3.
May I please? And the appellant is
petition at flag X
Yes, your lordship.
for engagement of Advocate J. Punya, case of S.K.Sahoo. You have filed your Rinama?
Yes, your lordship. I have filed my
Let us see. J. Punya, construction. ना कटियो का दिलीप कुमार साहू और तंका एसोसिएट करो अच्छा लिख दो here is the prisoner's petition of flag X wherein a request has been made for engagement of Mr. D.K. Sahoo as his advocate. Mr. Sahoo.
आप पर आउट है ये तो मिस्टर भूया
No, sorry. We don't.
मिस्टर भूया इन प्लेस ऑफ डीके साहब
Mr. Bhunya in place of D.K. Sahoo. Mr. Bhunya has already filed which is on record. The name of Mr. Dilip Kumar Sahu and his associates shall not be reflected in the graduate transcript. Yes, what is your submission?
Lordship,
Just now got the deposition.
Circumstantial, Lordship.
The
One
one
of the co-accused already released on bail.
copy the land counsel for the appellant provided the deposition copies of the witnesses, so also the copy of the bail order of the co-accused.
Appeal number 376 of 2018.
In CRL number
376 of 2008.
376 of 2018 to the London Council for the state in court today. We seek some time to verify the put of this matter. Favor of you?
Next week.
Can it be on 24?
Next week, 24th chao. 24 to 2025. ଆପଣ ସେ ଯୋଉ co-accused ର bail order ଟା ଦେଇଛନ୍ତି ତ? ଠିକ ଅଛି।
ଆରେ appeal ପାଇଁ discuss
ହଁ ଆସିବା କଥା ତ ଏଇଟା ଆସିନି। This matter along with କରିଦିଅନ୍ତୁ। ଯୋଉ CRL କେତେ ନା ଆଉଥରେ କୁହନ୍ତୁ?
376 of 2018, your lord.
376 of 2018.
Item 5.
5 your lords. So for the custody interview.
Has obtained its peculiar circumstances matter. In a peculiar circumstance, though the appellant was in a criminal reference has been acquitted in 2019, the appeal is registered on 2020.
बुझी हलानी
Right. In the criminal reference 1 of 2011, this honorable court has already acquitted the exercise 355.
ଆପଣଙ୍କର ଦେଖି ସେଟା ଏଟା ଜଜମେଣ୍ଟ ଟା କଲେ
जो कस्टडी सर्टिफिकेट नॉट कन्विक्टेड ଦେଇଥିଲେ ତା ବହୁତ କୋରି କଲା ପରେ ବହୁତ କଷ୍ଟରେ they have provided this today.
ତାର ନମ୍ବର କିନ୍ତୁ ଯୋଉଥିରେ ଆକ୍ୟୁଟ ହେଲା
ହଁ ST 151/35/2005
Criminal reference 1 of 2011.
and ST number.
Commission of Custody.
ओइडा ये हेतवा
Reference
डेथ सेंटेंस हेतवा लाइफ टाइम में रेफरेंस आसीबो दे डिड नॉट एग्री एटा को
No.
something wrong
It cannot be that. He has been acquitted by the session judge Sundargarh. And how this order was passed? This was passed by the ad hoc additional session judge Sundargarh, and the judge is now judge of this court.
मान है लाइक
The judgment के बीच 2011 ପରେ କଣ ହେଲା ତାପରେ ଏଟା ତ 2011 ରେ ତ ଆସିଗଲା ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ହେଲା
ଆଜ୍ଞା
ସେ ଅବଶ୍ୟ ଡେରିରେ ଫାଇଲ ହେଇଛି ଏଟା ତ ଲାଇଫ ହେଇଛି 302
30
अपडेट है अपडेट वाला 2019
But whereas the prosecution has been successful to prove the charge under section 302 against accused Rathalal Dhanwar alias Kunda. And therefore he has been sentenced to RI for life. No? এটা কি appeal করছি? হ্যাঁ রথালাল করছি। তো ଆପଣ କଣ ମାଗିଲେ ତାକୁ?
Previously the custody certificate ମାଗା। ସେଥିରେ ସେ custody certificate ଗୋଟେ ଜାଗାରେ indicate କରିଦେଇଥିଲା cover ଦେବେ ଯେ previous custody not yet convicted।
What judgment ଆମ ସାମ୍ନାରେ ଥିବ ନା?
ନାଇଁ ସେତେବେଳେ ତାପରେ ଯେତେବେଳେ କୋରି ହେଲା ଆପଣଙ୍କୁ କ୍ଲାରିଫିକେସନ ଆମେ ମାଗିଥିଲୁ ଯେ not yet convicted କେମିତି ଲେଖୁଛ 9 ବର୍ଷ 7 ମାସ 13 ଦିନ। Then a further custody certificate provided। ସେଥିରେ ସେ ଲେଖୁଛନ୍ତି 9 ବର୍ଷ କେତେ ମାସ କିନ୍ତୁ ଏଥିରେ ଯୋଉ not yet convicted ଟା blank ରଖିଲେ।
ମାନେ ଏଇଟା ହେଲା କି ରିମାଣ୍ଡ ହେଇଗଲା କି ସେଟା ସାଇଡ କରିକି
କାଇଁ ସେଟାରେ କିଛି ନାହିଁ।
ଆଡମିଟ ବାହାରିଲେ ଜଣା ପଡିବ ସେ କ୍ରିମିନାଲ ରେଫରେନ୍ସ ଟା କନଫର୍ମ ହେଇନଥିବ।
କିନ୍ତୁ ଏ ଯୋଉ criminal reference 1 of 2011 that this honorable court have I may question the honorable court has been pleased to direct that reference case disposed of the judgment of conviction and sentence dated 23/7/11 passed by the London ad hoc sessions additional session judge Sundargarh in ST 151-35 of 2010 is set aside. The appellant is acquitted from the charge under section 302 of the IPC.
କୋଉଠି କଣଟା ପଢୁଛନ୍ତି?
Criminal reference 1 of 2011 the copy I have provided.
ତାପରେ କଣ ହେଲା?
ଦିଟା କପି
ଏଇଟା
the opposite party Rathal Dhanwar state ଆସିଥିଲେ state ଓଡ଼ିଶା criminal reference file କଲେ।
କନଫର୍ମ କରିବା ପାଇଁ
କଣ ଏଇଟା କୋଉଟା ପଢୁଥିଲେ? ଏଇ ଯୋଉ 12/1/2025 ର ଲେଟର?
criminal reference 1 of 2011 order of this
my notes
ଦିଟା the opposite party Rathalal Dhanwar alleged Kunda be set up
just a minute. Number 7 data set appellant is acquitted instruction में जाएगी। You have been acquitted of it before disposal of you. It appears that
एक by 2000 may be called for
जो provision ଅଛି
395 3
no
395 3 surplus 3 any court making a reference to High Court under subsection 1 or subsection 2 may pending the decision of High Court thereon either commit the accused to jail or release him on bail on approved default.
Come to 318. 318 CIC, it says that if the accused zoners of unsound mind cannot be made to understand the proceeding, the court may proceed with the inquiry or trial. And in the case of a court other than the High Court, that means session judge, Jalava DJR, if such proceeding result in conviction, the proceeding shall be forwarded to the High Court with a report of the circumstances of the case, and the High Court shall pass thereon such order as it thinks fit. ତେଣୁ ଆଦିରେ କ'ଣ କଲେ ନା he was being found guilty. That is the reference କରିଦେଲେ in view of this. It's not a death reference. No. Death reference ଅଲଗା, a reference ଅଲଗା. ତେଣୁ most likely ସେ ଏ ଜିନିଷଟା ଆଦିରେ ଲେଖା ହେଇନି, ସେ ଯୋଉ ରେଫରେନ୍ସ ରେ ଲେଖା ହେଇଥିବ ଏଟା ପ୍ରୋନାଉନ୍ସ କଲା ପରେ ସେପାରେଟଲି ଗୋଟେ ଅର୍ଡର ପାସ୍ ହେଇଥିବ ଯେ perhaps he is unable to so and so the understand the proceeding, যেটা ରେକର୍ଡ ରେ ମାରିଦେଲେ ପଳେଇ ଆସିବ। ଆଚ୍ଛା ଲେଖି ଦିଅନ୍ତୁ, କ'ଣ ଲେଖିଲେ ଏଟା? ଆଚ୍ଛା, it appears that the appellant from the impugn judgment in this JCR that the appellant along with one Gobind Bhanwar alias Pachi faced trial in the Court of London ad hoc additional session judge Sundargarh in sessions trial number 151/35 of 2010 for offence punishable under section 302/34 of the Indian Penal Code. However, judgment and order dated 23/7/2011, though the co-accused Gobind Bhanwar alias Pachi was acquitted of the charge, but the petitioner was found guilty under section 302 of the Indian Penal Code. No sentence was passed. However, from the documents produced by the Land Council for the state, from jail it appears that in criminal reference number 1 of 2011, this court has been pleased to set aside the conviction and sentence of the appellant passed in the aforesaid case, and he was directed to be set at liberty, and accordingly the release order was issued. The document produced by the Land Council for the state is taken on record. Let the records of CRL REF number 01 of 2011 be placed on the next date. That is 24th of February 2025. Yeah. ଏଗୁଡ଼ାକ ଯୋଉ ଡିଫ୍ ଆଣ୍ଡ ଡାଉନ୍ ଯୋଉଗୁଡ଼ାକ ଥାଆନ୍ତି ନା ଆକ୍ୟୁଜ୍, ସେମାନଙ୍କୁ ପ୍ରୋସିଡିଂଟା ତାଙ୍କୁ ସେମାନେ ତ ବୁଝିପାରନ୍ତିନି, ତ ତାଙ୍କୁ ପାଇଁ ଏନଗେଜ୍ କରାଯାଏ ସ୍ପେଶାଲ ଇଣ୍ଟରପ୍ରିଟ କରିବେ ତାଙ୍କୁ, ତ ସେମାନେ ତାଙ୍କୁ ବୁଝାନ୍ତି କୋଉ ସାକ୍ଷୀ କ'ଣ କହୁଛି, କ'ଣ ସିଏ, କାରଣ ଆକ୍ୟୁଜ୍ ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହବ, so many things. But in spite of that, all the efforts, if the court comes to the finding that they were not able to follow the proceeding, then this trial will be concluded and they will be convicted, the accused will be convicted, but reference is to be made to the High Court whether that High Court may think fit, he may hear the appeal afresh, like it has been done in this, or if you set aside the order as such and try for a retrial. It type is the procedural infirmity. Yes.
Item 6.
In item 6, in Clark E, there is a prisoner petition lordship along with a proclamation of form. So I pray lordship may allow me to take a proclamation of form by which I can appear. That was not in
ଆପଣଙ୍କ ନାଁରେ ଆସିଛି
ଆଜ୍ଞା Clark E ରେ ଅଛି.
The point down sounds the point I want to engage, but I just not to touch. All right. Period the prisoner's petition at Clark E, wherein the prayer has been made for engagement of Mr. Rajesh Kumar Mahapatra, that is advocate. Mr. Mahapatra is present. The Wakalatnama, the prisoner's petition, he handed over to the Mr. Mahapatra, who gave it up and filed before the registry. Out on the courier of bail would have matter be listed on what a date they been.
May I be permitted to take this soft copy in the pen type?
The land council for the to be allowed only so the soft copy should be criminal appeal, memo, judgment, and deposition copies. Yes. ওকালতনামা কেবল দেবে এবং লিখে নেবে যে ওকালতনামা রিসিভ করবে। Please write down receipt ওকালতনামা date দিয়ে। Yes. Next case.
Item 7.
Item 7, P76(3) and S.K.
Item 8.
Item 8 custody certificate টা পড়ে আসছে criminal antecedent ପାଇଁ ଥିଲା
And seek mallet on Monday. I'll left today already to talk over phone with the IEC collecting.
Okay, it's criminal antecedent.
Mallet.
The land council for the
24th
state submits that he is yet to receive the instruction regarding criminal antecedent. The matter may be taken up week after. Land council for the appellant and put up this matter we commencing from 24 February 2025. Yes.
That's the last order.
Item 9.
Last order on 20. First 10 2024.
2024
So 21st 10 2024. That's it.
admit hela
For interim bail. I am trying for interim bail for
no ठीक ଅଛି ଯେ ଆମେ ଫାଷ୍ଟ ପଚାରିବାକୁ ଚାହୁଁଛି ଯେ आपको କୁହାଯାଇଥିଲା ଡିପୋଜିସନ କପି
ସବୁ
ଦବା
डिपोजिशन दे ଦେଇଛି ସବୁ
ଦେଇ ଦେଇଛନ୍ତି
ଫାଇଲ କରିଦେଇଛି ଅରିଜିନାଲ ଆଣି
ଆପଣ ଗୋଟେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଫାଇଲ କରିଛନ୍ତି
ହଁ ସେଇଟାରେ ଲର୍ଡସିପ ଅର୍ଡର କରିଥିଲେ କହିଲେ डिपोजिशन ପରେ interim ଅର୍ଡରରେ
ନାଇଁ ନାଇଁ ଠିକ ଅଛି ସେ ଇଣ୍ଟରିମ୍ ଇଏ ନମ୍ବର କେତେ ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ର
2263 ଆସିନି
2263 ଟା ତ ହଉଛି
Limitation.
limitation
ହଁ ତ
2262 ଟା ହଉଛି stay realization of fine
କେବେ କାଲି ବନ୍ଦ କରିଥିବେ ନାହିଁ
2261 এটা ରେଗୁଲାର ବେଲ୍ ପାଇଁ ଆପ୍ଲିକେସନ ଆସିନି କେତେ ନମ୍ବର ତାର
କେବେ ଫାଇଲ କଲେ
କେବେ ଫାଇଲ କଲେ
ସେଇ ଏକା ସାଙ୍ଗରେ
ଏକା ସାଙ୍ଗେ ଫାଇଲ କର
ଏଇଠି ଅଛି ଅର୍ଡର 2 ରେ interim application for bail and stay file shall be considered after
that is interim application means this is also IA means interim application so this is not an interim bail this is bail pending disposal of the appeal which you have filed but you say that perhaps you are interested in an interim bail interim bail maybe on various grounds let us say somebody is ill some marriage etc some death in the family so that is the bail this bail application is for till the disposal of the appeal so what do you say do you want to move this application or you intend to file another interim application
I'll file another interim application by tomorrow let's
Taking
he's in
the grounds on
taking the grounds okay
he is in the jail lordship
जेल रे तो एथे रही न रहिले कोन एटा सब तो जेल रे रहिया पड़िबो किंतु इंटरिम बेल रो ग्राउंड नेकिनी तारो डॉक्यूमेंट देकिन फाइल करबे कोन learning counsel for the appellant submits that he intends to file an interim bail application place this matter immediately after the interim application is filed by the learning counsel for the appellant yes
Item 10.
My name is to be corrected, Your Worship. And because that's why I couldn't get to know. Only after the intimation of the state council.
no it's all right now it is to be shown as Chandana Tripathi okay and you have received the brief
I have received, but I'm not. I'll take in pen drive.
you are having the pen drive today with you
I'll get it.
all right so the name of the Learning Council we reflected as Ms. Chandana Tripathi in the cause list instead of Chandana Mishra. Stop. Land Council for the Land amicus curiae request for supply of the brief to her. Let the jail criminal appeal was a prisoner's petition and the judgment copy be supplied to the Learning Council, Learning amicus curiae in her pen drive. So it's a life imprisonment. You just receive it, then we can place this matter for admission next week. Because matter will be listed on 17th of February 2025 for admission. No.
My lord, last occasion whereabout of the appellant, your lordship was directed. Appellant was religion based. My lord. So no, whereabouts
କଣ ପହଞ୍ଚିଛି ତ ଦିଅନ୍ତୁ
ଗାଁରେ ଅଛି ନା ଆଉ କୋଉଠି?
ହଁ ଠିକ ଠିକ ଅଛି ବଞ୍ଚିବା ବଞ୍ଚି ଅଛି ନାଇଁ କାରଣ 2006 ମସିହାର ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ତ ସେଇଥିପାଇଁ କୁହା ହେଇଥିଲା କାରଣ Alright, in pursuance of the order dated 19/12/2024, the Learning Council for the state has produced the report from the inspector in charge of Vishwanathpur police station, wherein it is stated that the petitioner is now staying at village Sitapur under Vishwanathpur police station and working as a laborer. Mr. Sharat Pradhan, Learning additional standing counsel produced there. The report is taken on record.
In which matters the accused is in custody? ଆପଣଙ୍କର ତ ଆଉ ଭିତରୁ କଷ୍ଟଡି ରେ କିଏ ଅଛି? ସବୁରେ ବେଲ?
So, you are ready, Mr. Tripathi?
Hello.
So you prepared that written note of submission, and is a case of direct evidence or circumstantial?
Yes, direct.
How many eyewitnesses are there? 4 eyewitnesses are there. So you assaulted by what weapons?
Axe.
Axe. How many blows you give?
Several blows.
Several blows. 4-5 blows. So 1 to 4 are the eyewitnesses. And doctor is PW.
Doctor is
PW8. Conducted postmortem examination. And PW8 has found
6
right side, 2 chop wounds on the right side of the occipital region, 1 chop wound on the occipital region, chop wound on this one, so neck, a good eye marching. So, anything you have brought out in the cross-examination of this?
No, but my lord, if your lordship go through the evidence of the IO and the constable, my lord, in this case, my lord, what happened, my lord, after committing the order, my lord, I was surrender myself before the policeman.
Yeah.
And it is the version of the IO and the constable man. But if you go through the arrest of the accused is very doubtful. From which place the
No,
IO
those are, you see, once you are unable to dislodge the evidence of the 4 eyewitnesses, coupled with the medical evidence, which has been adduced by PW8, even if you say that there is perfunctory investigation, that cannot be a ground to.
For the sake of argument,
Why he asserted? Why?
For that, my lord, I consider for the moment, my lord. My lord, that is a sudden provocation between the.
How do you say that? What is the evidence?
My lord, evidence is better that on that day, my lord, 4 persons are fishing in the village pond, and one of the present petitioner brother also fishing there. The deceased asked him that they have taken some loan from that person, my lord. The deceased asked the brother of the petitioner about that money, and there was a between the parties, and the present petitioner came and assaulted the deceased man.
Came and assaulted means he was not there at the spot.
Say asila seat spot ko the party.
Yes, you are right. The petitioner was not, the appellant was not there at the spot.
At the spot.
The quarrel was between the.
Shatrughan Sahu. Advance to Shatrughan Sahu. Shatrughan Sahu को से देतला आउ ता भरत साहू आसिला मारला.
So you came,
petitioner.
ଆପଣଙ୍କ ସାଙ୍ଗରେ କଜିଆ ହଉନଥିଲା, ଆପଣ ହଠାତ୍ ଆସିଲେ ଟାଙ୍ଗିଆ ନେଇକିନି ଯାହା କୁହାଉଛି ପୁରା ସାଇକେଲ
ଆସିଲେ ମୋ ଭାଇ ସେମାନେ assault କରୁଥିଲେ, କିନ୍ତୁ that evidence has not.
How you say that it will come under grave and sudden occasion? ଆଉ ତାପରେ ବ୍ଲୋ ଯୋଉ ଟାଇପ ର ଦେଇଛନ୍ତି 4ଟା 5ଟା ଲେଖା ବ୍ଲୋ ସବୁ ଗୁଡାକ ଟପ୍ ରେ, ମାନେ ମୁଣ୍ଡ ଆଉ ଇଏ ଆଉ କିଛି ଛାଡି ନାହାନ୍ତି ଆଉ। ଦେଖି ଦିଅନ୍ତୁ ଆପଣ ଏଭିଡେନ୍ସ ଟା ଦେଖି ଦିଅନ୍ତୁ, ଯଦି କିଛି କରିହବ, ଅଦରୱାଇଜ ଇଏ ତ ସେମିତି କିଛି ଲାଗୁନି on the face of it. सोमवार ଏଇଟା ତ ଆସିବ।